I may be allowed to call, bring it on record. Really grateful.
In item number 11, I filed one affidavit.
Please, your lordship. Lordship, I pray for listing of an IA, my lord, for preponing of a matter, my lord, which your lordship had fixed on 27/9, my lord. So this IA may be taken up tomorrow, my lord.
Why?
Since lordship has fixed that matter on 27, we have preferred an IA for taking it up on 26, my lord. Since my lord, my senior will be out of station from 27. My lord, matter relates to my lord, disqualification under the 10th schedule, my lord, of the constitution. My lord, the matter
I
is,
fix it on 27.
yes, my lord. So we have preferred this IA matter to be taken up.
Why? 26 then?
Lordship, or from 27, my lord, my senior will be out of station, my lord.
You see then.
Tomorrow,
Not
my
necessary. I'll leave. If they come, I'm not going to prepone it. Because this court is, there are a lot of matters fixed on a lot of days. See, this is already there. I can't. 26 already, 33 matters are there on the list.
tomorrow,
Absolutely no. Tomorrow, I have already 27 and new matters are coming and tomorrow not.
lordship, a simple IA, my lord, for orders, my
Sorry,
lordship, as my senior, he is the standing
take
counsel
an
of
adjournment,
assembly.
take an adjournment on that. Not doing.
Lordship, I'd like to mention a fresh item, my lord. It's a WPC, my lord. Writ petition, my lord. It may be listed tomorrow, my lord.
For what?
For motion, my lord.
Why?
There is an urgency because certain arbitration proceeding has been commenced, assuming wrong jurisdiction. Tomorrow.
Your lordships, my lord, in respect of item number 2 to 6, we have filed affidavit in opposition as that it is not on record, lordship. That may be called. lordship.
Thank for a listing for your address, my lord. Withdraw address,
Withdrawal?
It's a liberty, my lord.
What?
It's a liberty,
Which one?
WPC. 281924.
Matter is to be listed, then I will consider. With liberty, we'll see later on. First, let us. When do you want?
I'm the, for a.
Have it on 27th. Yes.
Receive the instruction. Take on the one.
My instruction is that the chances of a settlement seem remote, but and the chances of a settlement seem remote according to the instructions of my client, Lord, which is why, my lord, perhaps a adjudication on merits would be necessary for that.
So the difficulty is that, madam, at the level of the deputy commissioner, it would be difficult to take a call. So therefore, my lord, considering the situation, and the attending facts and circumstances, now the office of the deputy commissioner, district commissioner, Amin Gao, my lord, had moved now the revenue department. Initial proposal, my lord, for handing over the land for setting up that, my lord, Fancy Bazaar market that proposal came, my lord, from the side of the petitioner to the authorities in the GMDA. And under that circumstances, the GMDA authorities, my lord, took up the matter with the office of the district commissioner, Amingaon. Now, there are deliberations between the authorities, considering the fact that, my lord, the instant matter is under adjudication of this honorable court. And, my lord, the title of, my lord, the petitioner.
Why don't you go ahead with an acquisition process?
The acquisition process, but
Then in that regard, why I'm saying so, there's a reason why. The persons interested will differ. One will be the petitioners. The second will be those persons who are residing there,
absolutely,
because that is I think, you entering just with the petitioner will again create another chaos.
absolutely. Therefore, one, my lord, that is pending. They say, my lord, they are interested in adjudication of the instant proceeding. These are the persons who, my lord, came into occupation of the part and parcels of land, which they are claiming. By the
Well,
passage
they
of-
have no business out here to come here.
No, that is difficult.
You want, I can reject that petition right away in the morning. But the fact remains, an acquisition being done, then the authorities can very well hear the respective rights, whatever may be. But for that, how will you take care of the petitioner's interest without
So that is what,
conferring the title in respect to days of making the due corrections?
that is what. So under that circumstances, what has been proposed, my lord, by my learned colleague. So lordship, my lord.
No, because for me to adjourn it, again, there is no quarrel with that. I mean, I have no difficulties in that. But are you not going to have a roadblock there?
That is why, because, my lord, at the end of the day, my lord, if we initiate acquisition proceedings, we have to be very, very definite and sure about the persons, pattadars, who are the pattadars who are, because acquisition proceeding can only happen vis-a-vis the pattadars who are residing there. Now, my lord, over the part and parcels of land, who are the pattadars who are in occupation, because by now, my lord, several other persons' names had also been recorded, incorporated in the record of rights. So they have attained the status of a pattadar. Keeping aside, my lord, the claim of the petitioners that this plot of land, by virtue of this chain of events, now they are the rightful owners. So that ownership is, my lord, is yet to be adjudicated, my lord, in terms of the present proceeding. So under that circumstances, if your lordship would be pleased, my lord.
Because at the end of the day,
Yeah.
this court has to pass an order setting aside the review order. Because if I don't do it, you cannot have a free hand to go ahead.
Absolutely.
You may have whatever discussions, but at the end of the day, that
Absolutely.
review petition dismissal will have a consequence by which the petitioner's rights are being affected. You cannot take the petitioner's rights anywhere.
Yes. Because if we issue, because if the authorities might not move ahead with a might not propose acquisition process, they will naturally might not adopt the 1964 Act. Now, once the requisition notices are issued in terms of section 3, then my lord, the requisition person interested will have to be my lord serve notices under that. The schedule has to be, the land has to be properly described. And my lord, the pattada's name has to be, my lord, incorporated in that, my lord, notification, section 3 requisition notification. Or that, my lord, the pattadas who are in occupation now, they will come in, my lord, and they will be
Not
outside.
only that, if you go ahead, this court has to stay that also.
Yeah.
Because without the adjudication of the petitioner's right, it can't happen. So at the end of the day, whatever discussions you have, only way out is an adjudication on this.
Therefore, my lord, thus.
It is only before vacation you are buying time, that's another.
No, no, but- Hey, Lordship has
Because you
my-
cannot go ahead
No, no,
unless
not-
this roadblock needs to be removed and that can only be done by me
Now,
as it is Parthad. I
Lordship,
can release it from Parthad so that it can go
No,
to
no,
some
but-
other court.
yeah,
But the thing is, this is the only way out. This roadblock has to be removed.
Yes, now that since Lordship has fixed out the cat, my lord, so therefore, my lord, my respectful submission, let this matter come up for final hearing, because my lord, I have already filed an affidavit, rightly wrongly, my lord, bringing on record the present status. On the next date, my lord, on the next date, I will make all the revenue officials present with all the relevant records, so as to assist this honorable court
Better.
with the present here, because I am also not fully acquainted. They are very minute nitty-gritties there. They will come up with all backs of records. They are well acquainted.
Including that acquisition to that ceiling case.
Whatever it is there, whatever is
The
there in
ceiling
position,
cases.
yes. So Lordship may be pleased to fix up this matter, possibly, my lord, in the third week of November, my lord, if it is feasible. Any date, my lord, because first week and second week, my lord, I have some difficulty, my lord, with all humility, my lord. Third week of November, any date, my lord. If I see any hearing day, my lord. But it can be on 19th of November also, my lord. Yes, 14th of November also, my lord. 14th of November. No, 14th of November is Thursday.
Mr. R. Bapuja, learned counsel appearing on behalf of the petitioner respondent, Revenue Department has submitted that a request has been made by the district commissioner that for seeking an adjournment, taking into account the developments which have ensured on the proposal for relocation of the wholesale market from Fancy Bazaar, Guwahati. It is the opinion of this court that unless and until the instant petition is decided on merits, the respondent authorities, if allowed to go ahead with such a proposal, would have an impact on the rights of the petitioners. And as such, would be required that the matter, the instant petition be heard on merits and subject to the decision so passed, appropriate steps can be initiated by the respondent authorities. Accordingly, the court fixes this matter again on 14th of November at the top of the list, on which date an attempt will be made for disposal of the instant petition. The revenue authorities herein are directed to produce all the records in respect to the proceedings which led to in respect to the proceedings being ceiling case number
72.
372/1976, as well as the applications so filed by the petitioner which were rejected. Applications so filed by the petitioner under section 7(6) of the Assam fixation of land
Fixation of seating on land, or some fixation of seating on
1956.
land.
Sitting
On land.
on land holding 1956.
So in addition to that, the present record of rights have we also produced.
Lordship may be pleased to give this instruction as a part of the record, my lord. If Lordship so pleases, my lord. Lordship so
Absolutely
pleases.
no, these type of instructions I don't keep asking for time.
Obliged.
Item 226.
Oh, this is pertaining to that delimitation.
The number of government sites. They wanted to include the government within the municipal corporation.
They want to?
In the municipal, Sunchang municipal corporation. In inclusion of government site.
Village, the body so and so, so. You have submitted objections.
We have submitted objection, my lord. Now
Then you, those objections have not been taken.
not been taken. Now they have come saying some report has been filed on the objection, saying that it is not tenable, simple that, and nothing. 43 Q,
Yes.
just first it comes from that.
Yes.
243 Q, my lord.
And what are the additional books I will require now?
Assam Municipal Act.
Municipal Act and the other, you have another act, no? Recently you have come.
Security Board. Act.
You want to bring it under the new act. Municipal Corporation Act.
Municipal Corporation Act
Yes,
2022.
Yes. এনেকুৱা কিতাপ এখন আছে নেকি চাওকচোন, which the Advocate General is holding.
Assam
New
Books
books.
of Executive Business.
243 Q.
And Assam Rules of Executive Business 1960.
Mr. HRHOD, you were referring to
243 Q. Constitution of-
offenses and penalties.
Why not?
Offenses and penalties.
No. Q, my lord, Constitution Municipal.
243, okay, that is ZQ. Yes,
That is added by-
Constitution of
that's
Municipal.
the fourth amendment.
There shall be be constituted in every state and Nagar Panchayat and municipal corporation. Yes, tell me.
On this matter, transitional area, that is our case fall under three, my lord. Now they have stated there shall be constituted in every state, this three, in accordance with the provisions of this part, provided that a municipality under this clause may not be constituted in such urban area or part thereof as the governor may, having regard to the size of the area and municipal services being provided or proposed to be provided by an industrial institution. Then you will find this about two is important. In this article, a transition area, smaller urban area, larger urban area mean such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance of such other factors as he may think fit, specified by public notification for the purpose of this. Now let us take Assam Municipal Corporation Act 22.
So there is a requirement in terms with section 2743Q2 that there has to be a
Also
notification.
here also. it is visible. Now you have section 3 of the standards. Municipal Corporation.
And the first proviso, the proviso to section 243Q1 is in respect to industrial township, which we are not concerned. We are concerned as
Only
regards
support
as
two
to
by-
whether the question which is involved is as to whether a village
Right.
can be brought and when within the ambit of a municipal corporation. That's the issue.
Now municipal act, your lordship.
Yeah.
Municipal corporation 22.
Municipal Corporation Act. Yes, you give us one book like this. You have not given us books like this. You are holding books up.
We'll give one copy, my lord. no problem.
Yes, please. That day I have appropriated one book from Mr. D. Das, Mines and Minerals. One book from Mr. J. Sutia, Karbi Anglong.
This may be from my
So
side.
whenever there is a case of the petitioners, they have to give one book. Yes, tell me.
Section 3, man. 22. 22.
Yes.
Section 3, my lord. In terms of that article, my lord, the governor may, after making such inquiry as he may deem fit, and having regard to the population of any urban area, the density of population therein, the revenue generated for the local administration of such area, the percentage of employment in non-agricultural activities in such area, the economic importance of such area, and such other factors as well prescribed by notification, declare such area to be municipal corporation. So they have declared this notification made as per 6.3.1. Thereafter, you can see 2, subsection 2. Obligation of declaration. The notification about the constitution of the corporation shall be published in the official gazette and in at least 2 leading newspapers, at least one of which shall be in the vernacular to the inhabitants of the local area concerned. That's also done. Now 3, my
It's Sina. Sina.
publication of particularly is,
এখন আসাম মিউনিসিপাল অ্যাক্ট নতুনকে আহিছে
no, no, no.
বস্তুবোৰ দিব লাগিব।
Approve 3 for reason, no?
Yes,
Then my lord, 3. 3, 4 and 5 are important, my lord. 3. A copy of the notification shall also be posted in a conspicuous place in so and so, and also in the office of the municipal board. And such other public is that has been done, my lord. Nothing to say. Now 4. Consideration of objections. Any inhabitant of the city, town or panchayat area, in respect of which a notification has been published under subsection 2 of section 3 of the act may, your lordship, if he objects to anything contained in the notification, submit his objection in writing within 15 days of the publication of notification to the state government, to deputy commissioner or the district and the state government of the district, and the state government shall take such objection into consideration. Then 5. On the expiry of 1 month, your lordship, from the date of publication of the notification and after consideration of all or any of the objection which may be submitted, the governor may, by notification, constitute to such city, town, or any special area thereof as a municipal corporation. Now, my case is, my lord, 4. Subsection 4, my lord, 3, subsection 4.
so this will be another notification.
This is another, 5 is other.
No,
First-
no, 5
first
is
not-
another notification. So this seems to be 3.2 seems to be a preliminary notification.
Yes.
And pursuant to that, objections are sought for, and pursuant, and when objections are filed, due consideration would be made. And thereupon, it will be decided as to whether this to be brought.
Then second notification, final notification comes. So our whole case is under 4, subsection 4. And now your lordship kindly see the imperial notification, just your lordship kindly see. page 131.
Of which lead petition?
595, item 21,
595. Page
page 131.
31.
This is section 35, under 35. Whereas the proposal was received from so and so, so and so, on the basis of the proposal received from the deputy commissioner, notification for preparation of Silchar municipal corporation was published on 28/9/22. Set your lordship 3-1, not 3-2, man. Of section 3-1, an objection was invited from the inhabitants, city panchayat area so and so, the subsection 3-4. Whereas
So, Mr. Chaudhary, this is a type of a notification which is normally issued when you have the, just for example, the section 6 declaration under the Land Acquisition Act. Initially, you have the section 4 giving you the liberty to file your objections as regards the proposed acquisition. You object, then they decide this. But the question is this, that this has to have the subjective satisfaction which
That-
will
but
be
that's-
there in the records, not here, but in the records. They should have the
Exactly.
subjective satisfaction.
Here, what says matter, whereas after detailed deliberation, that I am on that one, next page, man,
Mm.
page 130. Whereas after detailed deliberations and examination of the claims and objection, the governor is pleased to dispose of it by rejecting the claims and objection which are found to be divorced. This is the important. Now they have come, your lordship, 167, page 167. Annex 3, in this case, oh, sorry, affidavit.
Yeah.
Your lordship will find this is a letter from deputy commissioner to the commissioner secretary to the PNL department.
Hmm.
Oh, sorry, urban areas.
Written by the DC,
This,
which is the justification.
yes,
You are appearing for whom?
this is item number
Nasiruddin
2.
Loscor.
Item number 2 is serial number 3, man.
Okay.
Your lordship will find objection against the inclusion of so and so. The petitioners present. Their contention is that the area is backward and agricultural land. Corporation tax will overburden the people. On scrutiny of the fact, it appears that their objection is not enough.
So the reason is this.
Similarly, my lord, item number, other items also same. Page 169. It item for none.
Which are the petitioners there? Means you are appearing for all the petitioners?
Yes,
All in all the batches?
yes.
Which are how many petitions are here?
Total five. Six,
First is 495.
495,
495 is by
605.
filed by whom?
Abdul
49.
Hannan,
495 is serial number 3.
2.
No. In this
Oh,
objection,
3,
this is 495.
yes.
This is Nazimuddin Loscor and 19 others.
595.
59, this is here, madam.
They are there.
Yes, same,
So this is 495,
495.
595. Okay,
595.
then
Item 3, my lord,
item
605.
3 is Mustafa Ahmed and Chaudhary and
Mustafa
four others.
Ahmad is your lordship will
Serial
find,
number?
serial number 21, page 169.
This is WPC number 605.
Fine. One quarter, sir.
Against the inclusion of Kongapur Part 2 as the density of the population is low, paddy land is there and there will be tax burden. Then
Then item 4, my lord, WBC 606.
606, that is
Number 25.
55. Six zero six.
Okay, sir.
Then
Then minus 3477. 24. Oh, no, sorry. 23.
Mazubur,
Musabbir Ali. 3477 22. This is Mario Loiva, is 26, serial number 26.
the president of number 6,
Yes.
Uttar Kishore.
Uttar Krishna.
Gaon Panchayat. This is serial 3477.
Yes.
Then
Then WBC 3892.
what is this? Hiranmoy Das,
Sriram Kumar Das. It is page serial number 24.
24. This one,
Yes.
Prasanjit Das and others.
Yes. Here what they say, my right side. Here it was actually part 4, part 6 and 7. Here they have stated, your logical right side, the petitioner present to the part 4 is not included in the proposed corporation act. One part, my. We have made objection against inclusion of part 4, part 6, part 7. Other two, they did not say anything.
Okay, your objection related to these
Related to
three
three,
parts.
three.
And 4 they have not brought in.
Not part. So we have
But
not.
you are concerned with 3
Now,
and
7, 6 and 7.
6 and 7,
6 and 7.
part 6 and 7.
Not 6. That is not mentioned here.
So that aspect has not been
Not-
considered. This is your case. Okay, now what else are there in the facts?
Factual part, my lord, you also will kindly see, paragraph 4 of my, paragraph 4, my, just
Of
of this. Paragraph 4.
of the repetition.
Repetition. Okay.
595.
595. Yes.
Okay,
Now kindly come to page 17, my lord, just page 17, paragraph 17.
yes.
16 and 17, my, that's 16 and 17, sorry, 16 and 17. In the present case, your lord's middle portion. Dudpazal Swansea, including a municipality, is one of the poorest area of the Godre Panchayat in the district of Cuttack, Nizamabad Mountains, that your lordship already said. Then your lordship will find within a municipal profession, rather than attempt to compel the people of that area to pay more taxes. When most of the people of that area are even struggling for the survival. Moreover, percentage of employment in non-agricultural of that is also very negligible, since the cultivation is the main occupation of more than 55%. Then there have been various schemes which is available only to Gaon Panchayat, MNREGA, Antodaya, and other things only available to the government villages, which they will be deprived of if they are included in the town.
Now this Gaon Panchayat is under 243Q.
Yes, both, Gaon Panchayat, your loss will find under section 43, section, my lord, 43. 43P, your worship, Article 20, Article 43P, definitions,
43B.
43B, but 43P, my lord, definitions are there. Panchayat definitions, 43B.
Means an institution by whatever name called of self-government constituted under section Article 243B for rural areas. Shall be constituted in every state, panchayat at the village, intermediate and so and so. Notwithstanding anything in subclause 1, panchayat at the intermediate level may be constituted in a state having a population. 20.
Meaning of population also given, my lord. P, G.
Both these amendments to the constitution were brought together,
74th amendment.
both.
No, only this part, madam, municipality part. Your lordship, part
Municipality
9,
was brought when?
part 9A. That is 74th amendment.
A.
Same, my lord, that is 73rd amendment.
So Gaon Panchayat came in
73rd amendment. 243, my lord, your lord, that chapter 9.
73rd amendment.
Yes. With effect from 24/4/93. That
And
is
the
chapter,
other one came in 74th.
that has come
74th. That
yes.
is on 1693.
93. Budget notification.
Almost nearby.
Amendment of 24/4/93. 2 months.
2 months.
1 month basically. 1/6 means
Okay. Do you have the statements and objects of these two amendments which were brought in? Because this is a vital aspect of the matter, taking into account the reason why these were brought in has an impact. Because now, therefore, would that be not a consideration? Because you are referring to 243Q. And when both the amendments of the Constitution happen almost at that relevant point of time, why the legislature ever thought of having a panchayat as well as this? Because otherwise, your basic case is, which you may develop at a later stage, I think, is that when the Constitution duly provides a setup of a Gaon Panchayat and all, and this setup of the Gaon Panchayat which is there would be would be nullified if the actions of the petitioners are the respondents are allowed, because of the fact that that is the reason why even in the 243Q there is a mandate as to which are the various considerations which are to be taken, more particularly in the explanation, as well as it is also seen in section 3(1). What are the parameters which are to be taken to differentiate it from the Gaon Panchayats?
3(1) is with related municipality. 3(1)
Understood.
yes.
3(1) is based on the
But only
explanation to.
part 9 and part 9.
It is in explanation to section 243Q. So the same wordings are being used.
Same model.
Wordings. So therefore, when those two enactments were brought in to the Constitution, and thereby one has gone for establishment, that means going to the root of the panchayat system. And the other is on a development scale in respect to the towns and cities out there where it is to be done.
That
Anyway,
is with-
if you don't have, I'll find out. Yes. So your consideration case seems to be on the basis that they have perfunctorily disposed of your objections. The reasons is just not tenable in respect to one, you have asked for many other parts, but they have only said about four, have not taken into consideration of the other.
Other two. This is because only one topics.
That is one, that is the last of the repetition,
last.
3892. But in respect of other, they have just said it is not tenable. It is
Simple.
understandable that in the notification, there would be no reasons assigned. But what is there, the reasons are to be taken into account out there in the order which was being passed. Or for that matter, could have been better explained in the affidavit filed by the authority concerned.
Only one thing might have made for that. If you like, kindly have the page subsection 4, 3, 4.
Huh?
3 subsection 4 and municipal.
Yes.
My lord, who is to consider, my lord, who is to take into consideration? You have any inhabitant, so and so, if he objects to anything, your worship, contained in the notification, submit his objection in writing within so and so to the state government, through the deputy commissioner of the district, and the state government shall take such objection into consideration. Now, what we find here, my lord, deputy commissioner himself, he has sent a report only, and on that basis, it was passed by the government. Now, government says after due deliberation and examination, whether they have done it or not. On that ground, stay was also given only because of that.
But that is your second ground.
So second one. The DC cannot. The state government simply on that basis, my lord, they have also different question about this. And we are clearly determined that they have to send it to the state government through deputy commissioner. And we have sent, my lord. Our representation, you know. He used to send one, my lord, that forward the objection as well as the files.
So first ground is objection perfunctorily disposed. Secondly, it is the state government who has to decide and not the deputy commissioner. There is no materials to show that the state government had decided.
Deliberated upon or examined. Page 126 by our representation. We have submitted the government through the deputy commissioner. Copy to the. Not the.
Now, these objections, there is no, how the objections are to be dealt with, decided, means you just file the objection and come back.
No, they have, by the, how they have to decide, it is decided with the state government. I have to file objection within 15 days of the objection notification. We submitted. Now it is their part,
Let us see the notification which was issued in pursuance to section 3(2).
section 3(2). 108.
Hmm?
28 September 22. Then 117. Then 117, page 117, 117. One 26, our representation, 126. Objection.
Okay.
Then page 130, your lordship.
Please have to look, 30.
Deputy Commissioner entrusted to the additional deputy commissioner to hear the objections, which is not permitted by. They have to send it to their comment or anything like. the statement.
Who is this? The district development commissioner is what post?
So nowadays, one of two, one is for administration, other for development.
Huh?
Both are deputy commissioner ranked.
Is hereby entrusted to hear and scrutinize.
Yes. Interesting. 1117. As 1117, they have stated, my lord, a particular person has been entrusted, it is page 117. Initially, they entrusted to one additional deputy commissioner, one Ashutosh Deka. 117,
No, that is for receiving.
yes.
That is for receiving.
Receiving.
Wait, that is,
That-
there is no,
But-
there is no, I think, any fault in that.
130,
130 seems to be a bit.
yes.
Because the hearing can only be done by the authority who is there.
State government.
And the authority has to be not, and
Not,
one would have
DDC.
understood.
DDC or ADC or this.
Okay. Anything more?
So this is, so basically the matter in the village area, development schemes are there. MREGA, other things, only available to the rural panchayat. They meant for panchayat, not for rural. area. This is also one of the grounds. Once we are included,
Have you mentioned anything in your
Yes.
reputation?
in our petition, we have mentioned.
What are the advantages of being in the Gram Panchayat?
Now panchayat, all the MREGA, Antardaya, the other things, all the, almost all the schemes.
So
Village
these schemes are otherwise not
schemes.
available.
No, for rural area not available. Now,
Where have you mentioned in your petition?
yes, your worship. There are drafts. Yes. And over that paragraph, mind of your worship will see 17, page 17, paragraph 7. Tax also will be much more the tax mind. Now they very nominal one mind of the rural areas, panchayat. The Federal Government of Assam has provided very beneficial scheme for rural people through the Gaon Panchayat.
An attempt to compel the people of that area to pay more taxes than most of
Yes.
the people do. No, where have you stated that these are the schemes which are not available?
I have stated what it is for rural people through Gaon Panchayat. That
Huh?
paragraph 17. The spirit not stated is not available, but my learned friend will say, might have into our information, nothing is available. Tax is also more, water tax, house tax, and everything. Development tax. nowadays much higher than my lord is. Even rural people, even town people also, they are not in a position.
They will be providing better facilities.
What, but we are not having water last 2 days here, Guwahati.
Huh?
We have to purchase the water, madam, in our Guwahati city. Madam.
Guwahati.
Yes. For last 2, 3 days was same thing happening. We are purchasing water from private source.
This is the act only came
So
in
we are not getting the amenities,
2022.
madam, but anyway, madam, but we are giving more
But
tax,
Mr.
madam.
Chaudhary, don't you think that you should have given better particulars that which are the schemes which should not be?
Anyway, I am
You
not
are
on
making a
that. That is
vague
my lord.
statement.
I am now. I only question about these schemes, Manrega, Mahatma Gandhi, that thing, all are available only for the cow panchayat. Rural people, not to this. People. So they will be deprived of getting all the benefits. On the contrary, they will have to pay more taxes. So how, from where they will get 85% of my lord, they are depending on agriculture.
And municipality and this Gaon Panchayats, they don't need to pay any tax.
They are paid tax, madam, nominal tax, madam, but keeping in view of the rural people, they are below poverty line. I've stated, madam, 70 some percent, paragraph 4, madam. 75 to 80% below poverty line. And for below poverty line also some schemes are there. Even if they go to hospital, they also get some benefits. The PM. Now government has come up with so many beneficial schemes, my lord, which are available only to those BPL. So,
Yes, Advocate General.
but if your lordship permit, I.
Yes, yes.
It's a pleasure to hear him that government is doing some good thing for the.
No. Why we are not blind to that one for the opposition and opposition. My other friend is also affected. I think he also purchased water.
I hope
sometime.
it is telecast is live and he will have some,
It is in the court only.
so he's appreciating the government in other words.
Anyway.
So, but
they
the
get-
second ground lordship, which he has raised, that the deputy commissioner or the subordinate officer, they are not competent to hear the hearing, that is not a pleaded case. But my reply is that the deputy commissioner and the subordinate officers are the agents of the government. That was not raised in the, that therefore I don't have a direct reply, whether there is some delegation or not. Their whole case is that they have filed objection. It was rejected, no grounds was given to them. That was their pleaded case. And the other part, which is the first ground. So in respect of the first ground, my submission is very clear. In fact, there are a lot of other complaints and objections. When we left some of the blocks of this particular village, Dudhpati, there was other of people who were claiming, they're requesting that the whole area should be converted to the corporation. So there are I have from the records already, I'll place it. So now in response to the first part, his lordship is pleased to come to paragraph 4.
Okay.
3, 4 paragraphs of the affidavit, of the affidavit. Affidavit in opposition filed by respondent number 3.
Yes.
Paragraph 5, lordship, in response to paragraph 4. Have lordship, page 143. The deponent begs to state that Dudhpati part 6, Dudhpati part 8, and the Boro Dudhpati grant constitute the Dudhpati Gaon Panchayat, as only Dudhpati part 4 part and Dudhpati part 6 part, which is densely populated, have been incorporated in ward number 1 of Silchar Municipal Corporation, and remaining part of both the revenue villages, along with Dudhpati part 8 and Bor Dudhpati grant, have been excluded from the corporation area. Therefore, only a small part of Dudhpati Gaon Panchayat have been incorporated in Silchar Municipal Corporation. It is also not the fact that the only means of communication in the area is country boat. The area is well connected with Silchar by Metal Road via Madharmukh, which has not been part of proposed municipal corporation. Apart from that, the construction of the bridge over River Barak at Annapurna Ghat have already completed, which brought the area within
100 meters of Silchar town. Then lordship will kindly come to paragraph 9. The whole revenue village of Dudhpati part 6 and part 7 was not included in the Silchar Municipal Corporation. Only the densely populated part of both villages have been incorporated. Then 11. The areas included from Dudhpati Gaon Panchayat are densely populated and transformed into an integral part of Silchar city with various kinds of commercial activities and satisfied all the parameters.
But
For
Mr.
inclusion.
Advocate General, why this affidavit is filed by the deputy commissioner?
We have filed.
Why not the
Because of
housing? Because the
factual parts.
housing board is the main person.
The main person, lordship, the notifications are all issued by the government, lordship.
No, the notification, the entire affidavit has to be filed by the housing board. Because the housing board is the housing, that is, they are the main person who should have, because they are to actually consider,
The government will have to repeat the same thing. If it,
whatever may be, but can the deputy commissioner
that
say
will be a
that?
very hyper technical issue, lordship, but the facts will not change. I'll come to it, lordship, but there is no bar because if they had raised this issue, in all probably there might have been some delegation of power. Now deputy commissioners are given lot of powers in the revenue department.
If there is a delegation of the power of this, then obviously the act will be bad. That you cannot delegate this. Because when the act categorically says that it has to be to the deputy commissioner and it is to be decided by, then how can you
The
delegate?
first,
it to the
now,
deputy-
if they had pleaded that case, lordship, there is not a whisper. In the argument stage, all of a sudden they have developed this argument.
No whisper?
No whisper. I have gone through again just now.
Against the equity opposition lordship, we have rejoinder also. lordship. Rejoinder file against the affidavit.
You had that document with you at page
Yes, sir.
113, which you have enclosed. There you have specifically mentioned about this. Why did you include page 130?
Regarding the statements made against paragraph 4597 of the affidavit lordship. That is page
No, this is
70.
regarding the factual part,
That
what
was-
my learned friend
that-
is referring.
Why
Law
did the
is very
stay
much-
why was the stay granted?
Whether it was placed before the governor or not, that was the issue. That is also not pleaded case.
Why did Mr. Ishari Chaudhary submit it on a different line? You said Mr. Chaudhary had categorically submitted that it is the state government who has to decide and not the deputy commissioner.
Yes,
And
yes,
that was the ground on which the interim order was passed. The interim order was passed on the ground that there was not placed before
not
the
placed
governor.
before the order.
In
of
fact, if I
governor.
remember correctly, on the last occasion when the matter was taken up, you have, Mr. Chaudhary has made, this is the only issue, whether it was placed before the governor.
The law is very much clear, lordship, section 3 and read with section.
Understood, but
143Q,
if you don't plead
that
there,
case has to be hearing to be completed by the government lordship. The case in the instant case law says that objection to submitted to the deputy commissioners and deputy commissioner will forward the same to the state government. That will hurt the matter, but in the instant case, deputy commissioner himself invited objection and himself heard.
understood, where is your statement? One statement will do. Where is it? You don't prepare your matter in this manner. This is why I told you. You say that about NREGA and all these things. Where is the pleadings out here? You may have a good case, but are you not spoiling it, being the lawyers out there? Or you just file the case just for the sake of it?
Page 108, lordship. Notification also in paragraph 3. Has delegated indication of delegation of some authority to the deputy commissioner. May I read it, lordship?
No. This is exactly the language which is being used in section 3, 4. Section 3(4) categorically uses the same language, exactly this language. Can you see? The days of publication and a month through the deputy commissioner of the district and the state government shall take such objection into consideration. Can you see the word? In the notification, submit his objection within 15 days from the date of publication in the Department of Iman through the deputy commissioner. This is exactly the language which is used.
Got it.
But Mr. Chaudhary, why haven't you raised this in your pleadings? This point that the deputy commissioner could not have decided? Not a
That
single
point,
whisper in your petition.
But ultimately, if there is a violation of law, my lord, suppose, for example, we might have some kind of committed, we permitted to do it. This is on our part, my lord. But that would not take away the kind of statutory right or anything else.
No, take your enlightenment. These are statutory laws.
Yes,
A statutory laws is a different aspect of the matter. If it was a constitution, I could have very well dealt with it. But if you are asking for an infraction to a provision of a statute, are you not required to plead?
I'm not saying I have, no, I am too. Suppose I have not done it. Whether court take into consideration.
How?
I am just giving one decision of the Supreme Court, my country.
Yes, tell me.
Yes, my dear, your lordship will find. This is. Page. If you lordship can pay from page 5 bottom. Then page 6, my lord, from second line. Your lordship will.
Yes.
Unfortunately, this aspect has not been noticed by the High Court, obviously because it was not brought to the notice of the High Court. The fact that a litigant before the court does not point out the relevant principles and provisions of law does not prevent the court from examining the issues involved in the lease. More particularly when the process which is the subject matter of the litigation before the court is inconsistent with the mandate of the Constitution. It is a settled principle law that courts are bound to take note of the Constitution.
Mr. Achari Chaudhary, you bring it by way of an additional application. This. And I think we need to
Yes, madam,
modify
it
this
be
interim
omitted.
order.
I am not justifying that, my that.
No. You need to bring this by way of it because this otherwise the loophole remains. See, there is a difference out there, what he has said. Yes, the constitution which is there, it is very well. One can very well say. But because if it is the constitution, it is the ground norm of the nation. Irrespective of what it is, you can very well ingrain the constitutional provisions. But a violation of a statutory law has to be pleaded.
We ought to have.
If it is not done, it will have a far-reaching consequences. Because what happens, the moment you don't plead, I take it up. The state may very well say that we have not been taken into account. We had no chance. But in respect to a constitutional law, there is no necessary, more particularly a fundamental right. There is no necessity of a constitution that you need to plead also. This court can on its own bring in the constitutional laws, more particularly the fundamental rights, but not a provision of this.
So the matter we got subsequent when they filed the affidavit, we got this report, hearing report. Earlier it was not there. We claim
And
subsequently, only when they
Mr.
filed affidavit.
Chaudhary, another thing. Why the entire notification has been stayed? We are only having 4 sets of petitions. Why not only this part of that notification be stayed, the entire other
No,
notification?
we are not
people
saying,
not
madam, the entire, we are also not saying. Our, so far,
What
our.
to say, Mr. Advocate General?
Lordship, regarding the first query, if let us see the impugned order. Who has taken the call? The facts were collected from the deputy commissioner, but it was the state government who had taken. Let us see the language. Lordship may have a different opinion. Do not have any.
No,
But
no,
let
Mr.
me place
Advocate
it.
General, Mr. Advocate, the question
No, no.
is when you are giving a hearing to a person by, not by that authority. It should have been you could have very well appointed some or ADCs of yours, or not ADC, some officer, some secretary level, joint secretary level of the housing department and get it hearing or done, whatever may be. But what is this area of the district development officer?
What was done? The facts were collected and who had taken the call? That is written in the impugned order. May I place it the order?
Where?
Page 131. Third paragraph.
No, this is a notification.
Let me see, Lordship. Let me place it. Lordship may have different opinion, but I have the right to place it before the court.
Yes.
Whereas 46 numbers of claims and objections were received from various individuals and organizations through the Deputy Commissioner, Kachar, along with specific observation of the Deputy Commissioner on the claims and objections. Whereas all details and deliberations and examination of the claims and objections. Whereas after detailed deliberation and examination of the claims and objection, the Governor of Assam is pleased to dispose of the petition by rejecting the claims and objections which are found to be devoid of merit. The fact collecting exercise was done by these officers. But the decision was taken by the authority, which is prescribed under the Corporation Act of 2020.
Mr. Advocate General, if you allow them to raise this point without an additional affidavit, this point I will take care of it. Later on, you may be in difficulty.
But today I am praying for vacating of the interim order.
No. This vacation, I may vacate it only as regards others, but not these.
There is a specific on later. Let me place that in the vacating petition. I have a specific letter from the State Election Commission. Let me place that.
We are not opposing election,
Election of what?
municipal corporation. Our question was
No, the question is when are the municipal corporation holding elections?
the concern,
This letter.
not yet notified.
Page 29 of the IM. In fact, out of 80 municipal corporation and boards, we conducted the elections in 2022 itself. Only 2 remained. One is Silchar.
Yeah, this one.
This letter is from the State Election Commission, the Commissioner of Commission Secretary Government of the Housing Department, holding of timely election to the Silchar municipal body, already delayed for more than 2 years on account of COVID and conversion of municipal corporation regarding. There are references.
Page.
Page 129 in the IA.
Which one? IA
IA is
1417.
in 2825 in 595.
Yes.
With reference to the subject cited above and letters under reference, I am directed to state that the election to Silchar Municipal Board has been kept on hold pursuant to letter dated 5/2/2022, which communicated the government's decision to constitute a municipal corporation to the Silchar Municipal Board. The letter stated that DC Kachar was entrusted with the responsibility to identify areas for the Silchar Municipal Corporation and submit a proposal to the government within 2 months for the government to notify the areas which shall form a part of the Silchar Municipal Corporation. However, the final notification was published only on 28/11/2022. It is noteworthy that Constitution of India mandates under Article 243U that the election to constitute a municipality should be completed before the expiry of its duration of 5 years. The process of election to all other municipal boards of Assam was initiated by the Commission in January 2020. But due to delayed delimitation exercised by the state government followed by COVID pandemic, the elections were finally notified on 9th February 2022 and completed on 9th of March 2022. The election to the Silchar Municipal Board, however, still remain pending owing to the later dated so-and-so cited above. As per Part 2 of the Section 5 of the Assam Municipal Corporation Act 2022, the state government by notification shall determine the number of wards into which the city shall be divided, the number of councillors to be elected to the corporation, and the number of seats to be reversed in favor of the scheduled caste, scheduled tribe, and women. The Commission, through its letter to the government, has been reiterating to carry out the delimitation and reservation of wards notification under subsection 2 of the Section 5 of the Assam Municipal Corporation Act 2022, so that it can proceed with the conduct of elections to Silchar Municipal Corporation. In this regard, order of the Honorable Supreme Court dated 10/5/2022 in Suresh Mahajan versus State of Madhya Pradesh may kindly be referred to, copy and close. In the said matter, the Apex Court has already clearly stated that ongoing activity of delimitation or formation of ward cannot be a legitimate ground to set forth an authority from much less the State Election Commission not to discharge its constitutional obligations in notifying the election program at an opportune time and to ensure that the elected body is installed before the expiry of 5 years term of the outgoing elected body. The Honorable Court also stated that if there is a need to undertake delimitation, it ought to be commenced well in advance to ensure the election of the concerned local body are notified in time so that the elected body would be able to take over the reins of its administration without any disruption and continuity of governance. Paragraph 14 of the order. The Apex Court has also directed the State Election Commission in the above matter to abide by the directions and observations in the order uninfluenced by any order of the High Court or the Civil Court on the subject of election of the concerned local government, as the case may be. It has also been clarified that the said order in Suresh Mahajan versus State of Madhya Pradesh is not limited to Madhya Pradesh State Election Commission, State of Madhya Pradesh, but applicable to all states, union territories, and the respective state election commissions to uphold the constitutional mandate. It has come to the notice of the Commission through letter dated 1/8/2023 from DC Kachar, the Honorable Guwahati High Court by orders in 5 WPCs, wherein the Honorable High Court has directed that in the interim, the notification to constitute Silchar Municipal Corporation shall not be acted upon. The government is requested to bring the above order of the Honorable Supreme Court before the Honorable High Court and proceed with the delimitation and reservation and issue the notification under Section 5(2) of the Assam Municipal Corporation Act latest by 31st August 2022. It should be 23 maybe. Therefore, in order to fulfill the constitutional mandate of holding timely election and in the light of above directions of the Supreme Court, the Commission therefore requests you to kindly look into this matter urgently and issue the notification under 5(2) of the Municipal Corporation Act 2022 so that the election to the Silchar municipal body can be notified. Lack of any progress in this regard may result in violation of the constitutional mandate and direction of the Honorable Supreme Court of India, the notification, etc. So this judgment I am placing. And also there are subsequent development of preparing the voter list, etc., which is there in this IA. So the complete facts are stated in paragraph 4. while we are praying for vacating of this order.
Where the records pertaining to these observations made at page 167? This is the letter written by which department?
Once
By the Deputy Commissioner on 4/11/2022, enclosed as Annexure 3,
4/11,
page 167 of the
Yes.
affidavit.
4th November 2022, Lordship.
Where the records of this hearing?
That was not called for, so I'm not keeping it right now. It is in the, we have to collect it, Lordship. Here, if Lordship is pleased to see one, serial number 22, the contra view.
Yes.
Thousand Sanatan Youth Group Silchar, they claim for inclusion of Dudhpati Part 1 to Part 8 and the areas of Ambikapur, Basantipur in the proposed Silchar Municipal Corporation area and enhance the total area of the proposed corporation feasible smart city mission of Government of India. So there are contra objections also.
So here you have rejected it,
Yes,
1 to 8.
we have rejected it.
So, but what happened in Dhupati?
In Dhupati, two parts were excluded. Rest were included.
No, 4 was excluded.
4 was excluded, and another part was excluded. In our affidavit,
But
we have-
here the claim was to include 1 to 8.
yes, day one, because partially it was already included.
Partially it was included.
It was included
When?
at the very beginning. Before the objection, when at the time when the objection was called for, along with that objection, we have annexed the total areas,
You know,
delimited
the-
areas of,
Whether these Dhupati, part 1 to part A
yes.
were included prior to the delimitation process.
No, it was not the whole one way. Yes, if Lordship is pleased to look at 108's annexure. While we issued this September 28 notification, we enclosed the proposed Silchar Municipal Corporation.
That I see. Then,
Here, ward number 1. Lordship will see boundary. Dudhpati grant is there, then part of Dudhpati. Which are the areas which are included? It is very clearly mentioned here. Along with the GIS. Highly sophisticated, Lordship.
this I understand, but it will be here. not
After
page
giving the
160.
demarcation, the proposed area ward,
No,
we
that's,
sought the complaint.
no, whether 1 to 8 were included.
No. What was included is indicated here.
This is
This
not,
is the proposed Silchar Municipal. After the objection,
Yeah.
there was no change in my humble submission.
no, because there was a claim at 22 that kindly incorporate 1 to 8.
All
All.
All
That-
was not in.
No, no, and that request was, the observation is, this objection is not tenable.
So what has transpired during the hearing, because full length hearing was taken place in our affidavit, we have stated. They appeared, they participated, they deliberated, they produced documents, everything was taken. The personal hearing was given to all the people. In our affidavit, we have very categorically stated. And the observations were forwarded by the Deputy Commissioner, his observation. He has not taken the decision. It is not possible also to fortify complaints.
Okay, you have the document where the decision-making process is there for, yeah?
At 2 o'clock, I can produce, it is from Dispur only we have to bring, because the decision-making process, Lordship is very clear, it is in response to that issuance of the notification of 28th November. So if that file is
Because
produced,
if you see in this particular document, yeah, affidavit,
let me place the affidavit, because the affidavit
No, we are-
clarifies everything. whatever is
Yes,
under objection.
I have read it now.
Lord,
By the time you have known it.
the
Kindly come
first
to paragraph,
affidavit,
yeah, I've read it. Paragraph 13.
no, paragraph 11,
Yeah, those I've read it. Paragraph
11,
13.
then 16,
No.
18,
Kindly read paragraph 13.
paragraph 13. Paragraph 13, the Tribunal bench said the petitioner submitted claims and objections for exclusion of Dudhpati Part 6, Dudhpati Part 7 from the Silsar, and the petitioner was duly heard, scrutinized, and observations were submitted to the Government Housing Department. So he has not taken a decision. Neither the ADC nor the DC. That is why they did not raise this issue in the writ petition. And our objections was also called from by the government of Assam through the deputy commissioner. If they were aggrieved that we do not want to submit it before the deputy commissioner, they could have challenged it at the relevant point of time. They have submitted before the deputy commissioner or his subordinate officer. And regarding the place,
A land acquisition.
whether
Act of
every
1896.
their other oral submission was that it was not placed before the governor. Every file of the executive is not placed before the governor.
No,
It is
that
not
I'm not,
mandatory.
that I'm not on that.
Yes,
Because that
one
is,
sixty-three, aid
they
and advice,
use
this is
the name of the governor, that I think Mr. Chaudhary would also not like to read.
The governor has three roles. One is executive, one is consular, the other one is
No,
judicial.
he's not making.
Yes,
That's,
but on that ground, the stay was granted.
yeah, maybe, but that is okay.
In fact, if I have, because the governor has three
No,
different
because that
categories.
is why I asked, no, because on that day, when I would think, had
Lord,
taken up the
On that day
matter,
also it was submitted.
that was submitted, it was not laid.
Today I
to
have
the-
all these very famous cases. The Rameshwar
No, not
Prasad, all
necessarily.
these cases are very clearly said how the governor will function. Whether it is a discretionary power, it is a constitutional power, and in case of schedule 10 schedule, it is the judicial power.
We'll take it up at 2, Mr. Because you kindly get that.
Lord,
And another thing, you ask your junior to look into it, is in this, because you see, why I'm saying, this Land Acquisition Act has a similar provision,
Lord,
5A. Now, when the notification is being issued under section 6, which is the declaration,
Lord.
earlier you have a preliminary notification that look here, we are going to acquire this land, what objections you have or not. 5A hearing is given, you can file your objections within a time limit given. Thereupon, a decision is being taken. The decision, the hearing out there is normally it is taken by but the declaration is being made by the approval. Kindly see here, you see, the hearing would be done under 5A by every objection on the ER shall be made to the collector in writing, and the collector shall give the objectors an opportunity of being heard. So the hearing therefore is being taken by the collector. And the collector hears it, the collector submits the report, and on the basis of that report, the section 6 declaration comes in.
Lordship.
Now, in this case, the hearing has been done by an authority
Yes,
who is not there.
yes.
How do you take care of that situation?
For that,
Hmm.
they should have challenged the September's notification.
Why?
Because September's notification, you submit everything to the deputy commissioner.
No, that is, as per the act,
Yes,
act also says that,
then
through
What?
the deputy commission.
to the deputy commissioner.
Yes.
So that has precisely been done. And what the deputy commissioner says in the column, Lordship will kindly come to the last column of that Excel sheet.
Hmm.
Page 23 or any page, Lordship, there are two identical. If Lordship is please to take my vacating petition, page 23. So name of the petitioner, President Silsar Town Congress Committee, subject of petition so and so, and observations. He has given the observation only.
Okay.
Whether that observation is bound to be accepted by the authority or not, that is not final.
But isn't it
Observation
when the state government shall decide, when the word used shall take such objection into consideration,
Yes,
means that state government has to apply its mind.
it's fine. So
On what basis?
preliminary, the observation has been given by the officer, the subordinate officer, maybe the deputy commissioner. whether that observation is binding on the state government. It is not independent mind because it is a fact collecting exercise. The facts were collected by the deputy commissioner and he has submitted everything lock, stock and barrel to the government. Government has applied its mind and government has taken a decision
Along with the claims applications.
because yes,
Whether
claims
the
and
whether the claim
in the
application.
previous slide, Lordship will say, in this
Yeah.
regard, report on the claims and objections is submitted below with specific observations for each claim and objection, and copies of claims and objection petitions are also submitted herewith for ready reference. So everything has been sent there. He has given his preliminary or prima facie observation, whether that observation is sufficient or not, because if some noting is also there, that has also gone to the state government.
Okay, you bring it at 2.
And last page, Lordship will kindly see, after all these facts stated,
This is for your kind.
this is for kind information and necessary action. So action has to be taken by the government, not by him. He is just a fact collecting agent and forwarded the facts.
Let us see the records at 2.
Lordship.
We'll dispose it of
Lordship.
this way, that way. But the only thing, if I dispose it of in their favor, should I only constrict to that area where they filed the objections or otherwise?
I'm sorry, Lordship.
See, just for example, if I dispose it in their favor, here only 4 persons have come, or 4 units, I might say, where 24,
Small
25
areas.
NA has come. Otherwise, in my opinion, the coordinate bench should not have stayed the entire thing. Because it has an impact on the development of the other areas also. Because once it
Everything
comes
is come to a
under,
standstill.
under,
And on top of that, it is anti-constitutional.
Huh?
It is against the constitution also.
the constitution
Yes,
is
because
there.
for 3 years, the mandate, because the language of the Supreme Court's order, the mandate of the constitution has to be strictly followed. And what the Supreme Court has says, no stay order may be passed. Even if there's a stay order of the High Court or the Civil Court also, the state election can proceed in terms of that Madhya Pradesh case. That I'm not pressing that. This is a letter where they have got it. That is not my argument. My argument is that all the objections were taken into consideration by the competent authority as prescribed under the law. A decision has been taken not to accede to their complaint, and government stayed with their final. And thereafter, this voter list with photographs, etc., were also published. Only thing is that we are yet to hold the election, whereas other identically placed.
No, you are yet to hold the elections. How do you hold the elections without that notification coming into effect?
That is why, Lordship, because of the stay order, therefore we have filed a vacating petition.
No, it's okay. We'll dispose it of today itself.
Lordship.
But only thing that if I interfere, if I interfere only as regards, should I interfere the entire? No, I don't think so. It may be only limited to the area where they filed the objection, because other people have not come before this court. Why should this court at all interfere in respect to others?
I leave that-
And
that
I'm
is
not
all.
saying that I'm going, but think about it. What
I
is
will
it?
not think that is Lordship. Whatever Lordship gives the order, either we comply it or we challenge it before the higher court. So we
The
have two
only thing
remedies.
is what is required, because the entire thing, the question does not arise. The only thing will be limited to this. Because the entire, otherwise the notification may be good for all others, because nobody has objected. Only a few people have objected.
And what
who
is the
have-
ground of objection? That while granting them relief also, Lordship will have to say, what is their ground of objection? Their ground of objection is that I lose my post as a Gaon Panchayat president. That is one of the,
That's already
which
done.
they are not arguing, which
I
they are
don't
not
want
arguing. Their whole contention is that they still want to continue as
Well, we
Gaon
are-
Panchayat president. That is their pleaded case. They are not pleaded, their pleaded case is not being argued.
No, that already expired, term already expired.
Oh, that is why.
So there is no question of the time when we file, then we are gonna.
So let him be
So that-
ready for the,
One point.
The only thing, Mr. Sorry, you had a case, but the drafting councils have destroyed it. whatever may be, the reason why I'm saying so is you should have put better particulars, NREGA,
yes.
what are the benefits, which are not. These are questions which are very vital. That if there is no development, what is there? They say that there is a development. And you have, I don't see it even in your reply, you taking up these points. Should have
Now, Lordship, why we have
just
done,
making up a petition coming before this court, you have not even
That
alleged
is
this.
my lord, one thing your lordship will see. It is initiated first, I think page 30 or 40. They have asked to hold a Gausubha meeting. And whether it is in favor of exclusion or in favor of inclusion. They have initiated on that. On that basis, matter proceeded. We submitted. The large number of the people have attended the meeting. They have submitted their things, my lord. So that is what we are on that one, my lord, district. It is exclusive gross violation of this, my lord, 3, 4, 5. It is their case, my lord.
Get your
Yes,
Lordship. I will go.
There are those tender matters. I have the records. The communication from the government, it has the annexure A, annexure 1, which will also was referring to. The draft of the tender, which is annexed, contains that same composition of the tender committee. So that is there. But there is a noting, your lordship, that specific noting pursuant to which the re-scrutiny was done. What had happened was after the first technical bits were evaluated, the technical evaluation was placed, the drafts of the technical evaluation was placed before the district commissioner, district collector for his approval. But by that time, since the complaints had already been received, he made a note on the note sheet saying that kindly re-scrutinize.
Kindly?
Re-scrutinize. So on that basis, your lordship, the second process was undertaken. So far as your lordship, so but two things, your lordship, which perhaps may fall for your lordship's consideration is firstly, whether the district commissioner has taken it upon himself to conduct a scrutiny process, or since he has been given the overall control of the entire tender process, which is within his rights to direct for a re-scrutiny if he is not satisfied. And secondly, your lordship, the act and the amendment to the rules which have been made, your lordship, that perhaps provides that though the shops, excise the off shops, your lordship, they are under the overall control of the government of Assam under the excise department. But the power to make settlements, your lordship, and to conduct the process for such settlement has been perhaps conferred upon the district collector. So in that view of the matter, he is within his rights, your lordship, to direct the tender scrutiny committee to re-evaluate because the
But
tender,
he is also a part of the tender scrutiny committee.
he was not a part.
He was not here,
Not
but otherwise he is a part of it. as per
Otherwise-
the tender
otherwise.
notice.
even. And there is a one very
So once the additional deputy commissioner does it, it'll be done on his name. He's the delegate.
he is the delegate.
So under such circumstances, isn't it he who have done it?
Then if in that view, your lordship,
So
once he has
can
done it,
at the behest of the deputy commissioner again,
yes.
a re-scrutiny on the basis of complaint be looked into? If somebody would have challenged, yes, the phone number, this account number was not provided, it is another aspect of the matter.
If it is deemed that he himself has done it, your lordship, and that the additional deputy district collector is his delegate, then perhaps he still reserves the power till the financial bids are open to direct for a re-scrutiny, your lordship, because till the financial bids are open, your lordship, no rights are vested upon any of the parties. And since the tender itself says, your lordship, there is one clause which I missed last time, that bids shall only be accepted if the mandatory conditions of the tender are complied with. There is a specific clause to that effect. So if the
No, here is not the question of the bids. He did not have the
He-
bank account.
he did not have that,
It's not that. He had a bank account. The bank account number was not mentioned in that document. So it is on the question as to whether this person concerned had accepted it on the basis of that amounts to a document itself.
So perhaps what is falling from your lordship is once they've applied their mind to it and arrived at a decision. So could they have revisited that decision on the instructions of a person who's perhaps
Of
a
a person
person
who is there again.
whose delegate is there?
No, the person who is there, because they have already accepted
Yes.
to apply accounts. You see, normally the courts do not interfere as regards the wisdom of the person accepting, because they are the drafters of the tender conditions. Now, the drafting committee of the tender conditions thought it, okay, these are the people, 4-5 people who will look into it. These 4-5 people have looked into it. And they found that this meets the criteria. Now, once it meets the criteria, therefore, they went and they have informed him that, okay, now we are going to open the financial bid. Thereafter, complaints are being lodged. In the complaint, the deputy commissioner now finds that, okay, again, re-scrutiny. Now, the deputy commissioner asking for re-scrutiny is another aspect, but the drafting person who have done it, where the deputy commissioner was brought within the fold, yes, the act says he will be the settling authority. Or the act says that he will be the person who will conduct the proceedings. Very well. But it is based upon a draft tender conditions, and what is to be included is only certain what one can say, only
Particulars of-
certain particular vis-a-vis which are required only for the purpose of this his particular district.
Yes.
Nothing more, nothing
Yes,
less.
yes.
So these instructions are very clear. So only this you can insert, nothing more than that. You cannot by yourself change the tender conditions which we have given the Commissioner of Taxes.
That same tender document, your lordship, also grants apart from the act, since the tender document also grants the deputy commissioner the right, your lordship, to accept, reject, or,
That is okay.
yes. So
He
once
has the power to accept, reject, but for that, to accept, reject, they have also formulated a principle that these are the 5 or 6 persons who will be there in the draft technical bid, and thereupon the financial bid will be.
apart from that, your lordship, there is a separate provision, your lordship, which perhaps the reading of that provision gives an impression that the deputy commissioner is given a supervisory power over the functioning of the tender committee. And what has happened, from what appears, your lordship, has happened from the file notices, after opening the technical bids and evaluating them, the tender committee did not take it. They placed the matter before the district commissioner, district collector for approval. So they deferred their decision to him. It was at that stage that he made a noting in the file, a small note in the file that kindly used. Then after that, the second limb of the second process has taken.
Let us see the provisions of that.
Yes, sir. What is the first? Relevant provision, your lordship, would be section 17, which says that no intoxicant shall be sold except under the authority and in accordance with the terms and conditions of a license granted by the authority prescribed in the rules framed under this act in this behalf. Then section 26, your lordship, says that the excise commissioner, collector, or any officer or authority in issuing any license or in making any settlement of shops under this act or rules framed thereunder shall be guided by such directions as may be issued by the state government from time to time, either generally or in particular.
You are referring to?
First I refer to section
17.
17, then section 26. 26(1).
The excise commissioner,
Excise commissioner,
collector,
collect.
or any officer in issuing any license or in making any settlement of shops under this act or frame therein under shall be guided by such directions as may be issued by the state government from time to time, either generally or in particular. may at any time, if it in the opinion can cancel any notice it calling for tenders for settlement in accordance with the rules framed under this act, or any tender received in pursuance of any notice or withdraw any shop from settlement of funds. Anything in this act, the state government may issue directions to the commissioner area, cancel any notice in accordance with the rules framed so and so. Inviting tender received in pursuance to any notice is cancelled under this section. The value of the court fees is fixed to such regard. Okay. So here the power is given subject to control of the government.
Control of the government. And how the government has sought to exercise its control is by laying down a procedure under Rule 114.
No,
Okay.
but has the government issued any notification, any directions by any notifications?
Originally, your lordship, 114 of the rules of 2016, it said that as it originally stood, grant of, is that page number 126 if the lordship has the same?
Yes.
114, grant of retail sale of foreign liquor off or on the premises, subject to Rule 279 of the rules. License for retail sale of foreign liquor off or on the premises shall be granted by the district collector with the previous sanction of the state government on payment of the annual license fee as may be prescribed by the state government from time to time. This rule there has been an amendment, your lordship. 114A has been inserted. I have the amendment here. This is the amendment. If your lordship has page number 3711.
Here.
It's at the bottom of the page, insertion of Rule 114A. In the principal rules after Rule 114, the following new rule shall be inserted, namely procedure for grant of IMFL off license. So rule number 2 would be critical, your lordship. The tendering process shall be carried out by a tender committee constituted by the respective district collector of the district. The tender committee shall consist of at least 3 members with requisite experience and competence, including that of financial matters. Then, your lordship, Rule 12. The district collector shall be the authority to conduct the process of selection of successful bidders for grant of license, provided that the excise commissioner, Assam, with prior approval of the state government, may authorize any other official to conduct the selection process and may also authorize any collector to conduct the selection process in more than one district. So, lordship, what has happened is 4 and 5 is also important. Yes, 4 and 5 are also.
So the tender committee shall prepare a list of technically qualified bidders after such scrutiny inquiry as it deemed necessary for a purpose. The list of such technically qualified bidders shall be published by the concerned district collector of the district.
So what has happened in this process is the district collector has not taken it upon himself to evaluate the bids. Since the onus of settlement and publication of the list is on him, he has said that he is not satisfied. He has asked them to re-scrutinize. So upon re-scrutiny, the same tender committee, they perhaps felt that in their wisdom, they felt that the bids of the petitioner were lacking in certain aspects and also when they rejected the bids. Because sub-rule 12 again says that the district collector shall be the authority to conduct the process of selection of successful bidders for grant of license. See, onus of evaluation is on the committee, but settlement shall be done by the district collector.
Was there any publication of technically successful bidder?
Yes, Your Lordship. It was informed to us, Your Lordship, that your bid has been accepted.
Then,
Then, Your Lordship, they are required to open the price.
so
with
after that, don't you think that you should have consulted with him before the exercising that power?
Lordship, my understanding is that till financial bids are open. He and process reaches a conclusion, no right is vested upon it because it is still at the stage of evaluation. Though the bid evaluation is to be done in the two bid system.
No, maybe, but when you see, if we come to 4 and 5, you'll publish. The publication is there the moment you inform him.
Yes.
So
That is-
under such circumstances, once the publication is there, he gets a right. He gets a right for consideration as per number 6.
Yes.
If that be so, in between that, if you halt his bid on the ground of certain aspects, isn't it necessary for asking him? I would have understood if he did not submit the document at all, but he submitted the document.
Okay, what perhaps the rule says that the list of technically successful bidders shall be published by the concerned district collector of the district. What appears, Your Lordship, is probably noting is that when approval was sought from the district collector, yes, there was a communication, no doubt, and that was even uploaded onto the portal also, Your Lordship. That is also reflected. But when the approval was sought from the district collector, that is the second part of Rule 5, then he said that in so many words that kindly rescrutinize. So since the process was still at the stage of evaluation of technical bids, that process is complete, but it was still at that stage. So the provisions of the Act rules and the tender document as well empowers the district collector to perhaps order a rescrutiny. And a rescrutiny, Your Lordship, if a rescrutiny,
Where? Where is it in the rules?
so a combined reading of, because it is completely under
So
the.
once you have published it in the technical portal, that these people have come in, where is it provided in the rules? Thereafter.
Because, Your Lordship, the process evaluation of financial bids will be, it's the next step, Your Lordship. If the district collector feels,
After 4, we see 5.
no, I understand, Your Lordship, but if the district collector feels that the mandatory conditions or if some conditions.
He
of-
was a part of the tender committee. He should have been better there. Why did he delegate it to his additional district commissioner?
When if the powers have been perhaps.
Okay,
delegated-
let us hear the other side. Who is the
Can I
person?
just take Your Lordship to read some of the provisions of the tender?
No more enough. The rest is for the division bench to look.
Just, Your Lordship, two provisions of the tender document.
Who is there for the other side? Yes, tell me. Otherwise, he will mind. I have not heard him and passed out.
Only thing, madam, that the DC was not part of the tender evaluation committee, madam. It was the ADC, madam.
Where is that the DC has any power after that? After 5?
The rules do not say so, madam, that the DC has the power, but if your lordship read.
I would have understood. They could, if there was anything out there, they could have very well asked him, what is the number? You have got this certificate. You are not satisfied. What is your number?
They
That's all.
could have, madam, but if they have chosen not to,
No,
madam.
this for making it technically you see, kindly see Rule 14 also. It is under these, only in exceptional circumstances, they are to resort to one bid.
Yes, 14 is when only there is only one bid. Here, there are two
This is-
bids, madam. One has
No,
been
no, no.
disqualified.
Not when only one tender when there is only one, if the license is satisfied with the, this is one tender when in your case, it is only one tender. The other has already gone for a 6. He has been made technically disqualified.
Only thing is that whether lordships will enter into that arena,
Yes.
that when the tender committee has taken a view. that these
Tender
are the
committee
assets-
has already taken a view
Yes,
and it has been published in the portal.
been published.
And
If
this
your
is
lordship
in
reads-
terms with that. Thereafter, the question is financial. Okay. Financial, yes, the tender committee, somebody said, okay, go for a re-scrutiny. They want to do something, I write whatever is there for his being considered for financial bid in view of the publication in the technical work. He may not have a right for getting a RIA, but a consideration is there on the basis of fairness. Fairness of the action would have been there where they should have asked the authority concerned, look here, this is the thing we are finding it difficult. He would have explained that, yes, this is my number. It is not a thing that he did not give the bank account. He said that this is a letter which is there, which says categorically, he may give the bank account number. That wouldn't have, no heaven should have fallen on the basis, would it? For the excise department? No. Asking that simple thing. Normally we don't interfere, but here is a case where after 5, it comes to 6.
Commission. In all fairness, he did not specifically point out the bid of the petition.
Understood.
That was the decision.
He did not. But the moment you have already done a technical qualification, and when it is published, the fairness of the action of the state authorities demanded that you have, now you want to take them out. We are not going to consider his financially. He has a right of being financially considered on the technical portal. That right he had. And you are depriving him of his right. Yes, you can. There's no quarrel, you can. But the question is, if you are depriving, then the fairness demanded that he should be asked, yes, look here, this is a document where he say that he is a particular person, he's a reputed customer out here, but you don't have your bank account number given. That's all. We are concerned about the state largesse. We are concerned about giving the best offer so that the state gets. Are we more concerned about how much less the state gets on the basis of two technical interpretation to be given? Well, let us dictate your judgment first. Then comes his. Which matter is yours?
Your 7 and 8.
One matter.
7 and 8. Same issue, Your Lordship. 7 and 8.
Both cases.
Both.
Same.
Exactly same, Your Lordship. Exactly same.
Which are the numbers?
Item 7 and
1384 and
item
1385. We got hold of two persons together on the same day. These are different, yeah.
Different.
shops. These are the, this is the status as it was reflected before.
Yes, Mr. Agarwal, you are appearing for one.
It says re-scrutiny minutes, so because there is a reflection in the portal also that there was a corrigendum and it was re-scrutinized, so because I have the latest status, I have the status as it is now, but even now it reflects that a corrigendum was issued and there was a re-scrutiny, the portal reflects that. So if what is following from my learned friend, that whereas when at that point, the portal reflected that it were open. I have no records to dispute that at this stage. Lordship may kindly let me have it. Lordship, the first line at the first column, the first row at the top of the page, it says that there was a corrigendum issue and the tender is reverted back to the stage of technical.
22-2.
22-2. But I only obtained this on 12th of September. Your Lordship. This is,
No, that is why it appears on top,
yes, yes.
on the right.
Yes, so I do not know what the status was on that day.
Now, he says that he was technically, it was reflected in the portal.
I was informed, Your Lordship, that your technical bid has been accepted.
Yeah, where?
Lordship, Your Lordship will kindly come to page 118.
118.
This is the message sent to me.
Hmm.
First was
Your
the
bid for the above tender has been accepted during technical evaluation by the duly
Duly
constituted committee and the financial bid opening has been fixed on 16th February 2024 at AI. In case of any clarification or feedback, you may contact ma'am. And what is this document? Annexure page 119.
That's the minute, Your Lordship, where my bid has been accepted.
Huh?
Technically.
No. Page 119, annexure 6. We are referring to
1384, Your Lordship.
1385.
1385, the other one.
It's the same document.
Lord.
Now, this is a 12120 is the by which you have been rejected.
Lord,
You are in which one? TSK?
this is TSK 10, Your Lordship. Six is 1384. And
Vallabh Jyoti Constructions and Ranjit Mishra. Due to non-submission of net worth certificate and APDCL no dues certificate. This is a different one. Oh no, we are concerned with which one?
TSK 10, Your Lordship, page 122 of 1385.
Your name is which one?
Lordship, this Swagatam Borgohai. This is the rejection.
Due to non-submission of the proof of bank account, the bank account solvency does not resemble the bank account.
And page 115 is the minutes where my bid was, technical bid was accepted. Your Lordship.
And the other case?
Other case, Your Lordship has already gone to 138.
No, it's okay. Is it in this minutes it is there now? Which one?
Yes. sir.
What is his name?
TSK 6.
Prasanto?
Gogoi.
TSK
6.
6. I do this one. Rejected, same. How do you get hold of two persons on the same type of mistakes being committed? Yeah. Yes, Mr. Agarwal, what do you want to say?
Both has been shown to my lord already.
Your TSK 10 is, what is your problem? It means somebody has been accepted. You had an alternative case, no? Means you have a case which is. Who? Your name is? Vallabh Jyoti, okay, construction. Yours have been accepted. Then it was given to whom?
Given to Rajiv Rajpal.
Okay, why you are challenging his?
Provides certain documents to be certified by the CA and the application, etc., to be signed by the tender concern. Go to an author. The balance sheet is not certified by the CA and the application of which is also out of the documents.
Application for? And you have filed it an objection. Oh, you did not file. You filed after the minutes. I remember, you filed after the minutes.
Financial bid.
No, yes, after the financial.
22 itself.
No, you submitted here. After 22 through.
Yes, 23rd I have submitted.
Yes, you submitted later on.
Technical bid was open on 22nd. I have submitted the objection on 23rd. Financial bid was open subsequent on 26th probably. 26 price bid open. Financial bid was open on 26.
No, the technical bid was also on 22nd.
22nd. I submitted
objection on 23rd.
Understood. And on that day, the financial bid was also
No,
open?
madam. It was open on 26 too.
Okay. It was opened on 26 too.
After opening the financial bid also, I have submitted representation. Thereafter, the license has been granted.
So you are into, your case and Mr. Bothakur's case is 1835, 1385.
Yes.
1385 is TSK 10 and his case is also TSK 10. Yes, Mr. Agarwal, tell me.
The rules has already been told to you. The rule 12, in this case, I would just like to pinpoint one aspect of the matter. That the entire Tinsukia district, there were around 15 or 20 shops were there. But the re-scrutiny was for all the shops. It's not a case that this particular TSK 10 was taken up for re-scrutiny and all that. It was not. It was for the entire Tinsukia district. They say that you go for a re-scrutiny for technical. That is one aspect of the matter. I would like to. And only 2 shops are being challenged here before it's on.
Hmm?
2. Shop number 10 and another shop is there. Huh? 6. TSK 2 shops are under challenge.
Hmm.
Earlier you will also be hearing the case of TSK 6. Well, my friend Mr. Eka appeared.
Anything?
Clause 11 is also definitive. Clause 11 of the rule.
Hmm.
Sub-rule 11.
Hmm.
The district collector for the district will call for the tender or re-tender as the case may be for grant of license in the case as approved by the excise commissioner by issuing a notification and by giving wide publicity so at least 2 widely circulated newspaper in Assam. Now, I'm leaving this, then your lordship will kindly see A, B, C, E, qualification criteria.
Hmm.
But on the other day, my lord was saying that who is the author? My lord, merely because they have sent a draft and all that of the document, the excise commissioner or the government will not be the author. Author will be ultimately the entire responsibility or entire power has been given to the district commissioner to have his tenders putting the necessary qualification criteria.
But did the deputy commissioner decide that? If we go by your submission, that the deputy commissioner is the author, did the deputy commissioner decide that look here, qualification, the bank statement means with the number. The bank statement, when we are asking for the bank account, it is the number which have to be provided. Did the deputy commissioner decide that? No.
The criteria.
Understood.
The
But
criteria
did the
that-
deputy commissioner decide that?
that tender committee decided.
Understood. So it is the same tender committee who have decided differently.
Yes.
So therefore, the question is that now the deputy commissioner is the author. Let us take the deputy commissioner, but deputy commissioner cannot be a melee. He has to get the approval from the excise commissioner. As for 11 itself.
The approval of the soaps
No.
Your lordship will kindly see that.
11.
11 I am reading
Where it
that.
is proposed to grant a year, the district collector here shall call for tender a year as the case may be for grant of Iman in
Yeah,
the
as
areas
approved by
as
the excise
approved by the excise
That
commissioner.
approval is already gone, my lord. Your lordship will kindly see the brief petition. If your lordship kindly see. I'll just pinpoint. I'm sorry, my lord. Affidavit of respondent number 3.
Hmm.
My lord, at page 137.
or it is mark 137, annexure A to the, my lord, the approval is already given on, my lord, 18th of September 2023.
Along with the draft.
Draft is, so.
And what is the scope of the intermeddling with that advertisement? By the deputy
My
commissioner?
lord, here they have written it is filled up with the required data pertaining to your district after finalization of the data sheet as provided at page 7 of the draft document.
So the draft which says that you only think as per your district, whichever is necessary. Otherwise, don't intermeddle with this.
That's true, my lord. My submission would be here, my lord. Your
Hmm.
lordship will kindly see. The direction of the excise commissioner, my lord, will not prevail. It is the, my lord, the rules will prevail, my lord, ultimately. If the rule provides, then it is the district commissioner who will decide ultimately. My lord, definitely, my lord, in all the districts, since this is for the first time, the tender process was
But if the rules provide, it is who will do it? It is the technical committee
district, technical committee will evaluate.
evaluate. Now the
Definitely.
technical committee has already evaluated.
They have evaluated, they said that all the technical bits are accepted.
Except.
Well, to that extent, my lord, I am not saying anything.
Now, once it is being done, I am only on one point. The moment a technical bid is qualified in terms with the rules, we are not as per our normal tender process,
I'm not-
which are there as per all these judgments of F1's Galaxy and all. We are not. There is a tender process mandates a particular thing is to be done in this manner. Here, the technical committee evaluates and says that the petitioner is okay. They publish it by giving him due information. Thereafter, there is a re-scrutiny. If they find anything, the moment he is technically, by operation of law, he has a right to be considered under 6.
For financial bill.
He has a right to be considered. Now, if that is the right to be considered, this aspect having now they want to reject him. Don't you think that they should have informed him that, look here, this is it. That is the basic fairness. We are concerned about the state largesse also. This is a case of fairness. Other contracts or tender conditions, many other tender conditions are there. But here the tender condition is regulated on the basis of this 114A.
40.
114A categorically mentions that he has a right the moment this technical bid is.
Yet the publication, so in the, my lord, portal, they have already informed. On, my lord, that's your bid, technical bid has been accepted. And financial bid will be opened on 16. But your lordship kindly see the clause, rule 5. It says that the list of such technically bidders shall be published by the district commissioner of the district.
It was given in the e-portal, therefore they got it. Are you saying that that particular document which have been issued was wrong? I don't think that the excise department is going to
The
say
Excise
that.
department say it will not be
No,
very
that you
difficult for
can't say
me to
that.
what, but my lord, ultimately.
A right
my lord,
is conferred.
Why, my lord, the thin line, my lord, the thin line between, my lord. As my friend has already argued, Mr. Pathak has already argued, that my lord, once the technical bid was opened, it was scrutinized, complaints were made. In the meantime, complaints were made, but my lord, ultimately the evaluation, whatever evaluation they have done, it was placed before the deputy commissioner.
Mr. Agarwal, you are in TSK 10.
Yes.
Now what do you want? No, this court is going to set aside that selection that is okay. But should I now remit it only back for the technical bid to be looked into? Or for the opening of a financial bid? Or-
Financial bid is also open, my lord, but so far he
Okay,
is
financial bid is known, but the technical bid, or should I ask them for going for a fresh tender for
concerned,
this? Better? Because otherwise you have a problem with Mr. Saikia's client.
Saikia's bid is lower than me, my lord, but Saikia is saying that no, you have. not
Yeah,
given this, you have
there
not
the
given
problem arises.
this. You have not given that. You have not given this, you have not given that. So, my lord, answers are there, my lord, definitely. Answers will be looked into by my lord. My lord will make balance of everything.
No, I'm
Yes,
just
best-
thinking, which will
best
be
way of, my
better?
lord, to remit the
Which
entire
will be
matter.
better for going for a fresh tender for this
Fresh
or relegating only in respect
Fresh
to
tender
them?
will be the best way to solve the
Best.
matter.
Can do perhaps better because now
Because now the otherwise financial bid is gone and everything is gone.
he would be a disadvantage because he would be at a disadvantage because
I-
he cannot.
He will be not only disadvantage, he has a big problem with Mr. Saike's thing. Na? Because there the technical committee has whatever, if you are so technical, then what stopped you from not rejecting his? If you are so technical on the account number, then why not him? Because you see, whenever you apply for any job, you are to submit a certified copy given by the chartered accountants. So not worried with that proposition. Their reason is whatever, maybe it is up to the website or not, but then also you have to give that certificate. If you don't give it, nobody is going to accept.
My lord, make a submission. My lord, I'm not arguing anything, my lord, but making a submission on that, my lord. If your lordship reads the clause, my lord, your lordship will find that, my lord, so far the income tax, my lord, balance sheet and my lord, computations are concerned, returned. My lord, they does not say that, my lord, it will be certified by a chartered accountant. But net worth certificate to be certified by the chartered accountant.
No, balance sheets also is required to be certified
Because,
when
Lord,
you are submitting.
I'm not supposed to be, my account, Lord, I'm not a company. My accounts are not required to be, Lord, audited by the chartered accountant. So I'm just pinpointing, my lord, because your lordship, my lord, I have read and I have understood, my lord, subject to lordship's here. Well, that, my lord, so far the, my lord, return is concerned, my lord, I don't think that is required to be certified by the.
No, for that authority to look into it, when you are giving it to an authority, it has to be certified. That is why they mandated it as per the tender, because that is the norm everywhere. You apply anywhere. Just for example, you apply for your visa also. That has to be certified. You apply for any other job, any other aspect for any matters out there, you need to also, these are certified which is required when you are submitting it. Because who is going to certify? Nobody can open your website. Can they open your, this particular, your portal as regards your income tax? Nobody can open it. So it can be only open. That is why it is to be certified. How do will they adjust as to whether it is false or true? In Assam, it is okay. We don't go into so much of fraudulent or falsity out there, but there are many other aspects outside where this very document can be made. There's no problem in making that document. You can very well make it. You need only the QR code. To get that QR code somewhere pasted out there, get any other QR code, put it out there, and thereafter put whatever you feel like. Very easy. For these people, it is very easy. So therefore, it is the required of a certification that when there is a certification by the chartered accountant, there is an accountability of the chartered accountant.
The accountability, my accountability is also there. Because
All
I
is
have
there, but
submitted
the thing is, they would not trust only you.
my
They will
accountability
also put the
there.
embargo on anybody.
My accountability is also
So
there.
better set aside that. And for fresh would be better.
Lord, we have already deposited the money.
Give it back. They'll give it back. Even they have a provision out there wherein it says that if a tender is cancelled, the court fee will be returned.
Huh.
So why will they not return you the amount? Okay, so this is there. So these three, I dispose it of one by one bunch. You put me on a very difficult position. So we will have it after that. I can't dispose of together your matter because it will have far
This
reaching.
matter is not somewhere reverse, my lord. In a different district.
He
Where it
says
says,
another
where it
estate.
says that no, you have not given, no, that is not, I think the certification of chartered accountant. The same thing appear in his.
My big value was 51 lakhs and the job has been granted at 14 lakhs only because of that minor irregularity. As per the clause, there is a provision to waive that minor. Whereas in respect of the injury.
We'll look into it. Let me first dictate this one. Who will come back? 2 o'clock, I have another matter. Then I'll dictate this. We'll finish it up today. These matters should not. You are there, Mr. Bonik, anywhere in these matters? One,
But tell me the reverse of this. There.
one,
Item number 10, your lordship, that is.
1516. It's okay. We will take 1516 separately. First, I'll just write now then. There's another matter with, that a matter at us. Just take, I'll dictate it in the court. First, I'll finish up the other matter which was there. We need to finish up. These three will be done with one judgment. There's another matter? Oh, okay. This matter, there is another matter where I'm dictating. Yes, where are the records? Records. Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioners in the instant batch of writ petitions, and Mr. T. Soikia, the learned advocate general, assisted by. Got your records?
They have sent me the whole note sheets. I have asked them to send me those 418 pages also. So from E5, from E5. From
Or should we take,
further,
should I take up the matter tomorrow at 2? Tomorrow, day after at 2.
more at 2 o'clock.
Tomorrow night, day after. Tomorrow is a very busy day. I only want to see as to whether these people have considered it.
Because the deputy commissioner has given, after he sent the first batch, then the further clarification was sought. Then details was given on every point. And thereafter, the legislative department verified, the ministries have verified, everybody verified, and finally the notification was. The notification. Further details are required.
This is for me, na? This paper is for my,
They have printed it because it has been
okay. I can put a mark out there. It'll be easier for me.
the second round that is, it becomes an elaborated objection.
That is what I'm saying. There I need to,
There is the application of my method. And then further clarification was not from the.
heard Mr. H.R.A. Chaudhary, the learned, we dispose it of. Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by some appearing on behalf of the petitioners in the batch of petitions. And Mr. D. Sekia, the learned advocate general, assisted by Mr. D. Nath, appearing on behalf of the state of Assam and the other respondents. In the instant batch of petitions, the petitioners herein have assailed the notification dated 28/11/2022, issued by the Commissioner and Secretary to the Government of Assam, Department of Housing and Urban Affairs, whereby the final notification was issued under subsection 5 of section 3 of the Assam Municipal Corporation Act 2022. For short, the Act of 2022 to constitute the Silchar Municipal Corporation with words with boundary marks annexed as Annexure A along with a map as Annexure B. The issue involved in the instant petitions is a legal issue as regards as to whether the consideration of the objections in terms with section 3 of the Act of 2022 have been done in accordance with the provisions of the said Act. The grievance of the petitioner, as have been submitted by the learned senior counsel appearing on behalf of the petitioner, is that the objections which were submitted by the petitioners have been perfunctorily disposed of without showing that there has been any consideration. In addition to that, the learned senior counsel appearing on behalf of the petitioners had also submitted that in terms with section 3(4) of the Act of 2022, it is only the state government who is to decide such objections and not by the deputy commissioner. And in the instant case, it would be seen from the enclosure to the petition, to the affidavit in opposition, that is the communication dated 4th of November 2022, issued by the Deputy Commissioner, Kachar. It would be seen that it is the decision was made by the consideration and the decision was made by the Deputy Commissioner, and the state government did not further make any endeavor to make any further consideration. To decide the questions which have been raised by the learned counsels appearing on the questions which have been raised in the instant petition, this court finds it very pertinent to take note of certain relevant provisions of the Constitution as well as the provisions of the Act of 2022. Part 9A, capital 9A, was inserted to the Constitution by the Constitution's 74th Amendment Act 1992 with effect from 1/6/1993. In terms with the said part, the municipalities were granted a constitutional status. Article 243Q stipulates stipulates as to how the municipalities would be constituted. The said article, being relevant for the purpose of the instant dispute, is reproduced hereunder. From a perusal of the above quoted article, it would be seen that sub-article 2 of Article 243Q provides the parameters when the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance or such other factors as may be deemed fit specified by public notification for the purpose of the part Roman 9A. The above, the said, therefore, would be the parameters as constitutionally mandated. To be taken into consideration for the purpose of considering as to when a transitional area or a smaller urban area or a larger urban area can be brought within the fold of municipalities. This aspect of the matter is also reflected in section 3(1) of the of the Act of 2022, which stipulates the mode as to how a declaration of the intention to constitute a municipal corporation area is to be made. Taking into account the relevance of section 3 for the purpose of the instant dispute, the same is reproduced hereunder. A perusal of the above quoted section would show that subsection 1 of section 3 of the Act of 2022 mandates that the inquiry which is to be carried out mandates what are the parameters of the inquiry to be carried out to declare an area to be a municipal corporation. The parameters stipulated in subsection 1 of section 3 of the Act of 2022 appears to be in consonance with subarticle 2 of Article 243Q of the Constitution of India. Subsection 2 of section 3 of the Act of 2022 stipulates the mode which is to be carried out prior to issuance of the final notification in terms with section 3(5) of the Act of 2022. The process has to be initiated with a publication of a notification of a declaration in the form of a notification in the official gazette and in 2 leading newspapers, at least one of which shall be in vernacular language intelligible to the inhabitants of the local area concerned. In addition to that, it is also mandated that the said notification be published, it be pasted in a conspicuous place in the office of the Deputy Commissioner of the district, or where there is a municipal board, also in the office of the municipal board, and such other places as the state government may direct. The publication of the declaration in the instant case is not in dispute. Next. Subsection 4 of section 3 stipulates the the manner in which the consideration is to be carried, consideration of the objections which are being called on the basis of a notification issued under subsection 2 of section 3 is to be considered. The said objections are to be filed within 15 days from the date of publication of the notification to the state government through the deputy commissioner of the district, and the state government shall take such objection into consideration. Subsection 5 of section 3 stipulates that on the expiry of 1 month from the date of publication of the notification, that is the notification under section 3(2), and after consideration of all or any of the objections which may be submitted, the governor may by notification constitute such city, town, or any specified part thereof as a municipal corporation. In the instant case, the notification, the impugned notification dated 28/11/2022 is the notification which is issued in terms with section 3(5) of the Act of 2022. Taking into account the dispute involved in the instant case, the dispute revolves around subsection 4 of section 3 of the Act of 2022, which stipulates the manner in which the objections are required to be considered. The grounds on which the said notification, the impugned notification dated 28/11/2022 have been challenged, have already been mentioned here in Supra. The question which therefore arises is that whether the said grounds merits this court during the course of the hearing. This court, upon perusal of the materials on record, as well as hearing the learned counsels, including the Advocate General of the state of Assam, had sought for the records on the basis of which the consideration was made by the state government. In pursuance thereto, the records were produced and the relevant note sheets were also placed before this court. You don't claim privilege, no? On this note sheet, you don't claim privilege. So I'll put it on record as a. The said note sheet, the copy of the note sheet which was produced is kept on record and marked with the letter X. In the instant case, the 4 writ petitions pertains to the objections so filed, by the petitioners how many petitions are there? 5 or 4?
No, total this petition five.
Five,
Yes, total writ petition five.
five, way past, say, four, no, five.
One. Five writ petitions.
Have been filed by the in the instant case, it would be seen that there are five writ petitions. In WPC number 595/2023,
23 by.
the petitioners have alleged that the objections so submitted as regards the inclusion of Dhood Patil Part Roman 6 and Roman 7 in the proposed municipal corporation area. In WPC number 605, na?
Yes.
oblique 2023, the petitioners have raised objection against the inclusion of Konakpur Part 1 area in the proposed Silchar Municipal Corporation area. In 1, 2, 3, in WPC number 606/2024, the petitioners have raised objection for exclusion of Tupkhana GP from the proposed Silchar Municipal Corporation area. In WPC number 3477/2023,
Yes.
the petitioners have raised objection against that in the inclusion of Uttar Krishnapur Part 1 from the proposed Silchar Municipal Corporation area. In WPC number 3892/2023, the petitioners have filed objection against the inclusion of Dhutpati Part 4 bracket Eforbasti and Mosughat Mosughat bracket from the proposed Silchar municipal area. First, it is the contentions of the learned senior counsel appearing on behalf of the petitioners that in the communication issued by the Deputy Commissioner to the Commissioner and Secretary to the Government of Assam Department of Housing and Urban Affairs, the said objections have been rejected merely by stating that the objections are not tenable. It is the further case of the petitioner that in respect to the exclusion of Dhutpati Part 4, which is the subject matter in WPC number 3892/2023, the petitioners had objected to the inclusion of Dhutpati
6 and 7.
6 and 7 also. But there is no reference to the same in the communication dated 4/11/2022, and the respondents and in the said communication it has been mentioned that Dhutpati Part 4 was not included in the proposed Silchar municipal area. On the other hand, the learned Advocate General drew the attention of this court to serial number 22 of the communication dated 4/11/2022. And there was a submission wherein the claim for inclusion of Dhutpati Part 1 to Part 8 and the areas of Ambikapur, Bazantipur to the Silchar municipal area. Which was rejected. Why did you refer to 22, Mr. Division?
There are two opinions regarding the same area. Somebody wants, the other party don't want. So they are completely placed.
But that has been also rejected.
Some areas were taken, some areas were still retained. When part 4 was not considered.
Part 4 is not, but what about 6 and 7 is anyway considered anyway? No, it may be here, yeah.
Till number 3.
No, it will be here. Let me look here.
6 and 7 are already included, serial number 3. Relationship of order. For the part and the value. Here of. That means it was already linked.
Serial number 13, my lord.
No, no, here they have changed it. As regards this, একটু লেখক, হ্যাঁ, একটু লেখক, হ্যাঁ। Have, when he said that although has stated about this, today, Mr. Desaker, the learned advocate general, however, submitted that although in the communication dated 4th of March, November 2022, it was mentioned at serial number 24 that Dhupati Part 4 is not included in the proposed corporation area, but later on deliberation, it was mentioned, it was brought in.
Paragraph 5 of my.
It was brought in,
Paragraph 5.
taking into account that the population density of the area was also increasing, and the construction of the two bridges have been completed, and work of the approach road is going on. Full stop. Full stop. This court have also taken note of that pursuant to the communication dated 4/11/2022 being submitted before the Commissioner and Secretary to the Government of Assam Housing and Urban Affairs Department. The state government upon perusal of the claims and objections as well as the letter dated 4/11/2022. Requested the deputy commissioner to submit detailed specific observations against each of the 46 numbers of claims and objections. Pursuant thereto, the deputy commissioner had submitted a communication on 14/11/2022, providing detailed observations against each of the 46 numbers of claims and objections. For the purpose of the instant writ petitions, it may be relevant to incorporate the objections, the specific observations of the Deputy Commissioner Kachar insofar as the objections which touches on the instant writ petitions. The same are incorporated hereinunder. Yellow code. Huh? It is further seen that pursuant to the said objections, pursuant to the communication dated 14/11/2022, the matter was taken up for consideration by the Commissioner and Secretary of the Government of Assam, Housing and Urban Affairs. From the above specific observations so made after the state government had requested the deputy commissioner to make, had requested comment, would show that the observations are specific to the objections so filed. Pursuant to the said objections, pursuant to the said observations so made, the record further reveals that on 17/11/2022, the Commissioner and Secretary to the Government of Assam Housing and Urban Affairs Department had thereupon perused the same and took a decision to reject the objections which have been found without merit, and further directed that the final notification of the Silchar Municipal Corporation be approved subject to vetting of the legislative department. It would also be seen that thereupon the matter was placed before the concerned minister, who had also approved the same on 26/11/2022. It is on the basis thereof the decision, the notification dated 28/11/2022 have been issued. In view of the above materials and the office note being, or as well as the records being perused, the question therefore arises as to whether the state government had duly considered the objections or not. The answer has to be in the affirmative, taking into account the materials on record and what have been observed herein, what have been reflected herein above. Apart from that, the reasons which have been assigned on the basis of the observations so made, apart from that, the reasons assigned, apart from that, the observations so made by the deputy commissioner, which was duly considered in the opinion of this court, is in consonance with the provisions of section 3(1) read with subsection sub-article 2 of article 243Q of the Constitution. Accordingly, this court finds no ground to interfere with the impugn notification dated 28/11/2022, for which they both the writ petitions on the ground, and accordingly, the writ petition stands dismissed. Interim orders, if any, stands vacated. I made it X. It's a part of the record. Tomorrow, when they file an appeal, they will find it. But one thing is that, Advocate General, you got in the process of this case a word of commendation from the.
But that he should not use outside man.
Huh?
It is confined to this courtroom.
Huh?
It is confined to this courtroom, man.
Everybody, and see how the observations made by the Karnataka High Court.
এইখন লৈ গ'ল এইখন কাৰ হয় এইটো এইখন ক'ত লাগিলে ন এইটো ৰেকৰ্ডটো ক'ত গ'ল ন এইটো আপোনাক দিলো নেকি নাই দিয়া ন এইটো এইখন হা ইয়াতে সেইটো য়েল্লো কৰা আছে ন
So, no, but that is selective. As I can see.
হা
Benefits are selective, my lord.
There may be a modification. What else?
only to the
To that extent. Obliged.
এইখনত আছে না তো ISI সব এইখিনি ভৰাই দিম
Came 7 to 10, finding it.
এটা আছে না? আচ্ছা। So your license have been stayed, na? Huh? In that TSK 10, it is stayed. No license have been issued. And what about the other one? Mr. Endeka's matter?
Same, both method.
Heard Mr. Esbot Thakur, the learned counsel, appearing on behalf of the writ petitioners in WPC number 1384/2024 and WPC number 1385/2024. And Mr. PJ Saikia, the learned senior counsel, assisted by Mr. A.K. Gupta, appearing on behalf of the writ petitioner in WPC number 1496/2024. Mr. K.P. Pathak appears on behalf of the Excise Department of the Government of Assam. And Mr. K. Agarwal appears on behalf of the respondent number 5 in WPC number 14, in Mr. K. Agarwal, assisted by Hemdas, appearing on behalf of the private respondent in WPC number 1384 and oblique 2024. And 1496/2024. Full stop. And you? Endeka appears for the private respondent in WPC number 13. Mr. Roy Chaudhary, has your person got the commissioner and secretary done or not? Commission.
My lord, yes, said that they have called him over telephone to pay the amount online.
Yes. And commission will be done or not?
Paid, I will pay it online, they will be done.
Okay, very good.
It's item number 21.
I remembered it. Your seat has however been taken by.
Let him occupy.
All the three repetitions are taken up together. Taking into account that the issues involved in the repetitions, that is WPC number 1384/2024 and WPC number 1385/2024 are similar. And the issue involved in WPC number 1385/2024 is interconnected with WPC number 1496/2024. The material facts which arise for consideration is that the a tender notice inviting EB was issued on 29/11/2023 by the district collector, Tinsukia district, thereby inviting shopwise electronic bids bracket e-bids for grant of Indian-made foreign liquor bracket IMFL retail off licenses in the district of Tinsukia at the locations mentioned in the list of shops contained in the e-bid document. At this stage, it is very pertinent to mention that the said bid document Mr. Pathak, you showed me one document whereby the draft was sent, I said, on the last occasion. Na? Wait, that. Of which document? It is very relevant to take note of that the bid document in its draft form, draft form, was addressed to the district commissioner Tinsukia by the commissioner of excise, Assam, by the communication dated 18/9/2023. With the direction that the required data may be filled pertaining to the district after finalization of the date sheet as provided at page 7 of the draft bid document. In pursuance thereto, the bid document was published in the website https://assamtenders.gov.in. In the same bid document, there are various conditions stipulated. Clause 2 of the said bid document stipulates the following. Stipulates as hereunder, page 34 of Pabode, 1384, page 34 of Pabode. From a perusal of the said above mentioned clause, it would be seen that an individual, comma, a partnership firm, comma, a limited liability partnership, bracket LLP, or a company registered under the Companies Act 1956 or subsequent enactment, who has proof of filing income tax returns for the 3 financial years out of the last 4 financial years, that is 2019-20, 2021, 21-22, and 22-23, duly certified by a charter accountant, is eligible to participate in the bid. the impact of clause 2 of the bid document would be seen in clause 6, which stipulates as to what the technical bid should consist of. Amongst the various documents which have been enlisted, one of such document is inverted comma copy of income tax returns along with balance sheets for the year 2019-20, 2020-21, 2021-22, and 2022-23, bracket, any 3 years in sequence, bracket close, and the statement of inverted comma net worth, inverted comma close, as certified by our charter accountant. Therefore, it will be seen that this requirement of the documents has a direct correlation with clause 2, which is an eligibility criterion. In addition to that, are you a partnership firm? That person who has got it, you are a partnership individual. At this stage, it is very particular, very pertinent to also take note of that the above quoted clause as regards the document and the above stated documents is in respect to it is also very relevant to mention that amongst the very other documents as mandated in clause 6 of the tender document, an application, the duly formed, the eligible bidder, the bidder has also to submit a duly filled up application form as per Annexure A. From a perusal of the annexure A, it is seen that at clause 12, this is your case, na? There is a column with the inverted comma, details of bank accounts, bank account bracket S, bracket আকৌ দিব, proof to be submitted. In the said column, there is it has been further provided in the tabular form the name and of the bank with address, the type of the account, as well as the account number. In the instant batch of repetitions, this court is concerned with two shops, IMFL shops, retail shops, offline. Correct. IMFL of two IMFL of license shops. That is TSK 6,
Pengeri,
Penegri,
Pengeri, or
Pengree, and TSK 10, Gelapukuri, bracket urban. In the shop, that is TSK 6, Penegari, two persons, that is the petitioner in WPC number 139585, and the private respondent in the said petition had participated, only two persons, na? Participated in the said process. In TSK 10, Gelapukuri urban shop, six persons participated in the said bid process, including the petitioners in WPC number 1384/2024 and WPC number 1496/2024, and the private respondent therein. Pursuant to the submission of bids, at this stage, it is further pertinent to mention that in the bid document itself, and more particularly at clause 3. How the tender bid committee is to be constituted have been specifically mentioned. In terms with clause 3, the district collector or the additional district collector of the district as nominated by the district collector shall be the chairman. In addition to that, there would be 3 members and a member secretary. The superintendent of excise of the district or the senior most excise officer of the district, if there is no superintendent of excise, would be the member secretary. And the senior most official of the National Informatics Center, NIC in the district, the finance and accounts officer in the district, and the subdivisional officers and the deputy superintendent of excise in respect of the shops located in the respective divisions of the district shall be the members. In terms with the said constitution, the tender bid committee carried out the evaluation on 13/2/2024. In the said minutes so recorded, as regards the shop Penegri (TSK 6), both the petitioner and the private respondent in WBC number 1835/2024 were decided, were held to be technically qualified and were held to be technically qualified and entitled to be considered for the financial bid. In respect to TSK 10, the technical advisory committee, the technical committee had rejected the bid of one bidder, namely Sri Bhobesh Borgohain, as he falls under the rural area. However, the technical bid of other 5 bidders were accepted and were held to be eligible for financial bid. Okay, let me come back. In respect to the shops TSK 6 and TSK 10 were duly intimated in the portal that their bids have been technically evaluated and accepted by the technical committee. Subsequent thereto, the record reveals that certain complaints were received by the deputy commissioner, district commissioner, district collector. And on the basis thereof, district collectors, in respect to certain complaints were received by the district collector. In respect to the eligibility of the technical bids of other shops. And as such, by the office note, by the communication dated 15/2/2024, the district collector directed that there should be again another re-scrutiny of the technical bid. Accordingly, a re-scrutiny was carried out on 22/2/2024 by the same committee, by the same technical committee. And in the said re-scrutiny carried out, the petitioner in WPC number 1384/2024 and the petitioner in WPC number 1385/2024 were rejected and carried out, and the petitioners in petitioner in WPC number 1384/2024 and the petitioner in 1385/2024 that technical bids and as such the technical bids of petition number so and so were rejected in respect to the shops TSK 10 and TSK 6 respectively on the ground of non-submission of the proof of bank account and that the solvency certificate does not resemble the bank account. In 1385, did you submit the solvency
Yes.
certificate?
Yes. Page 111.
No, on the ground of non-submission of the proof of bank account. First. Immediately thereafter, the petitioner in WPC number 1496/2024 submitted a representation to the district collector on 23/2/2024 informing the district collector that the private respondent bid was not technically eligible, was not technically qualified, in as much as the certificates, in as much as the copy of the income tax returns and the balance sheets so submitted by the private respondent in WPC number 1384 oblique 2000, 1496 oblique 2024, who is also the private respondent in WPC number 1384 oblique 2024, were not certified by the charter accountants. However, the said representation was not considered, and the financial bid was opened on 26, no? On 26 to 2024, wherein the private respondent in WPC number 1834 oblique 2024 who is also the private respondent in WPC number 1496 oblique 2024, who got it? Pallab Constructions? No. Who got it? Manoj Agarwal. Pallab Jyoti Construction. Now, who got in TSK 10? Was recommended to be the successful bidder and for issuance of the letter of acceptance. In respect to TSK 10-6, the private respondent in WPC number 1385 oblique 2024 was also recommended, taking into account that there was no other eligible bidder. TSK 6 is what?
384 is TSK 6. 1385 is TSK 10.
बदलाई दिनु, हाँ? Private respondent in 1385. 13 TSK 6 is 1384. It's just as the was recommended as he was the sole eligible bidder. It is under such circumstances that the 3 writ petitions were filed before this court. It is relevant to take note of that while issuing notice by this court had also directed the respondent authorities not to issue the license to the private respondents in the writ petitions. The record reveals that pursuant to the affidavit, pursuant to the writ petition files, the respondents have respondents, including the respondent authorities, including the private respondents, have filed their affidavit in oppositions. Whereby the stand taken by the respondent authorities were justified. I've heard the learned counsels appearing in the backdrop of the above. This court finds it relevant to take note of the respective submissions made by the learned counsels appearing on behalf of the parties. Mr. S. Bottaku, the learned counsel appearing on behalf of the petitioners in WPC number 1384 oblique 2024 and 1385 oblique 2024 submitted that all the documents which are necessary in terms with clause 6 of the bid documents were duly submitted. However, in the application form wherein at clause 12, the requirement of submission of the bank account, details of the bank account was mentioned. The same were also furnished. And in support thereof, certificates were enclosed.
Page 117.
1-1. That the petitioner is a reputed customer of the said bank. Yeah, however, submitted that in the said certificate, there was no mention of the bank account. The learned counsel submitted that from a perusal of clause 12, the respondents have only sought for the details of the bank account, which the petitioner have duly provided in Form A, in the application form itself. There was no mention in the said document, in the said column, that the said document, that the proof has to be in respect to there was no mention. Yes, Mr. Bottaku, there was no mention of.
Also, there is no mention that the proof that the in the the certificate issued by the bank, this should be specifically the
Bank
account number.
account. There was no mention that in the certificate to be enclosed, there was a requirement of putting the bank account number. He further submitted that taking into account the amendment made to the Assam Excise Rules 2016 by the Assam Excise Bracket Amendment Rules 2023 and the insertion of Rule 111 small a, capital A. The respondent authorities, after having held that the petitioner was eligible, petitioner in both the petitions were eligible, as per the technical bid, could not have again rejected the technical bid, inasmuch as upon being notified that the petitioner was technically eligible, the petitioners were technically eligible, the petitioners also had a right accrued to be considered for the financial bids in terms with sub-rule 6 of Rule 114A bracket 1. The learned counsel submitted that if the petitioner had a right to be considered for the financial bid, and that right is sought to be curtailed on the basis of a right to be curtailed after having been already declared to be technically qualified, the petitioner ought to have been given an opportunity to explain. The opportunity not being granted makes the action of the respondent authorities unreasonable and unfair, and thereby violates the mandate of Article 14 of the Constitution. Anything else? Huh?
No.
Mr. P.J. Soike, the learned senior counsel, appearing on behalf of the writ petitioner in WPC number 1496/2024, submitted that the respondent authorities ought to have rejected the bid, the technical bid of the private respondent on the ground that he did not submit the copy of the income tax returns along with balance sheets for the respective years and the statement of net worth as certified by a chartered accountant. The learned senior counsel submits that the replies to the justification so given in the affidavit, they've given a justification. So given in the affidavit is completely misconceived, taking into account that the copy of the income tax returns as well as the balance sheets cannot be verified by the authorities themselves unless the said authorities approach the income tax authorities. It is under such circumstances it was mandated in the bid document that these income tax returns and the balance sheets were required to be certified by the chartered accountant. The learned senior counsel further submits that a further perusal of the bid document would show that in respect to proprietorship firms, there is a further requirement of a net worth certificate, which is not there in the case of partnership firms as well as company directors of the company. The learned counsel submitted that in the case of partnership firms, what is required is copies of the income tax returns of the partnership firms, which are duly certified by the chartered accountants. And in the case of a company, what is required is the copy of the income tax returns duly certified by the chartered accountant as well as those of the individual directors. The learned counsel therefore submits that the acceptance of the technical bid of the private respondent is a clear infraction to the mandate of, to the bid document, and the manner in which it has been accepted clearly shows an unfair, unreasonable, and irrational mode have been adopted in order to favor the private respondent. Anything else?
That need to be signed.
He further submitted that not only the certified copy, not only the copy of the income tax returns of the partnership firm, of the income tax returns as well as the balance sheets were not certified by the chartered accountant. Even the application form which was submitted by the private respondent was not signed in all the pages. Good stuff. He submits non-signing on any of all the pages would amount to is the requirement taking into account. Why? It's mentioned anywhere. Huh?
7.
He further submits that that as per clause 7, there is a requirement that the registered bidder sign where all paid. Submitted that in terms of clause 7, it is the requirement that all pages of the documents submitted by the bidder has to be signed by the authorized signatory and shall also be affixed with the bidder's entity stamp. Isn't that the clause? Mr. K.P. Parkontra, Mr. K.P. Pathak, the learned counsel appearing on behalf of the excise department, submitted that Hmm? He will see. That the district collector, in terms with the amended rule 114A, and more particularly Roman 12, or 114A bracket 1, and more particularly Roman 12, is the authority to conduct the process of selection of the successful bidders for the grant of license. He further referred to Section 26 of the Assam Excise Act 2000 and submitted that the excise per contra, Mr. K.P. Pathak submitted that in terms with Section 17 of the Assam Excise Act 2000, for short, the Act of 2000, no person can be, no intoxicant can be sold except with the under authority and in accordance with the terms and conditions of a license granted by the authority prescribed in the rules. The Learned Council therefore submitted that in terms with the Assam Excise Rules 2016, for short, the rules of 2016, Section 100, Rule 114 stipulates, 114 Roman 2 stipulates the grant of retail sale of foreign liquor off or on the premises. The Learned Council submitted that in terms with the said rule, the foreign liquor off or on the premises license shall be granted by the district collector with the previous sanction of the state government. In consonance with Rule 114 bracket Roman 2, comma, Rule 114 capital A bracket 1 Roman 12 stipulate that the district collector shall be the authority to conduct the process of selection of successful bidder for the grant of license. On the basis of the said provisions, the Learned Council submitted that the district collector, apart from being a member of the technical committee, has also the supervisory powers conferred to see to it that the process of selection of the successful bidders is done in accordance with the tender conditions as well as the provisions of the Act of 2000 and the rules framed therein under. The Learned Council therefore submitted that in the instant case, after the technical committee had decided on 13/2/2024, had in its minds decided the technical eligibility, the same was placed before the district collector for approval. Upon receipt of certain complaints, the district collector, therefore, being the supervisory authority, directed re-scrutiny of the technical bids. And in that process, it was found that the petitioners in WPC number 1384/2024 and WPC number 1385/2024 did not submit proof of documents that as regards the bank account of the petitioner. He therefore submitted that the question he therefore submitted that there is no illegalities in respect to the rejection of the petitioners in the petitioners in WPC number 1384/2024 and 1385/2024. Technical bid. Huh? But when it is technical bid is in the question, why, how can you say?
Once he is not qualified.
He further submitted that as the petitioners in both the writ petitions, that is the 1384 and 1385, are not technically eligible, they cannot challenge the recommendations so made in favor of the private respondents. Yes, what is the contention for the other one?
Requirement for signature. The committee is, tender committee is, because this party was qualified the first round with the round vote. That signatures.
No, the certificate. Charter accountancy.
They held it clear.
The Learning Council for Excise Department submitted that in respect to the certification to be given by the charter accountant to the income tax returns as well as the balance sheets, the technical committee have decided, have held it to be directory. And as such, the wisdom of the say technical committee be not interfered with, ought not to be interfered with by this court on the well-settled principles of law. As regards the non-signing, as regards the fact that the private respondent in WPC number 1496/2024 had not signed all the pages of the application form, the Learned Council submitted that the said statement is factually correct. However, the tender committee had decided that that was not necessary to sign on all the pages. Mr. K. Agarwal, the learned senior counsel, appearing on behalf of the private respondent in WPC number 1385/2024 and 1496/2024, submitted that a perusal of the tender conditions mentioned in clause 6 would show that it is only in respect to the net worth certificate which is required to be certified by the chartered accountant and not in respect to the income tax returns and the balance sheets. Anything else? Application form? Right? Solvency certificate is otherwise required. But then why did he give it?
And then it can be a function. But a bank statement. Or not,
Mr. K. Mr. K. Agarwal, the learning senior counsel for the submitted that what was required in terms with clause 12 of the application form is proof of the bank details and not a solvency certificate. The petitioner was just required to submit a document showing could have submitted the passbook, the checkbook, or even a certificate from the bank stating that the petitioner is a reputed is a customer having a particular bank account number. He therefore submitted that as the petitioner had not submitted the said document, petitioner in WPC number 1835 have not submitted the said document. The said there is the petitioners petitioners bid was not technically qualified, for which at the first space itself, the petitioner's bid ought to have been cancelled, rejected. However, it was inadvertently not done, which was later on corrected in the re-scrutiny. As regards the submission made by Mr. P.J. Saikia, the learned senior counsel, that the petitioners have not signed, the petitioner, the private respondent have not signed in all the pages of the document, application. The learned counsels, senior counsel for the private respondent submitted that the same is not required, taking into account that clause 7 only refers to the pages of the documents to be submitted and not the application form. Yes, Mr. N. Deka, anybody's submissions, same submission, adopt. Because you are similarly situated with him, no? Except that you don't have that problem. He also have the problem with charter accountant, no, na? The Mr. N. Deka, the learned counsel appearing on behalf of the respondent, private respondent in WPC number 1834 of the 2024 had submitted that the bit of that had made similar submissions to that what Mr. K. L. Karwal, the learned senior counsel, have submitted. And as such, for the sake of brevity, this court is not repeating the same. This court further finds it pertinent, next paragraph, to take note of the reply made by Mr. P.J. Saikia to the said submissions, senior counsel to the said submissions, wherein he further submitted that the requirement as clause 7 is not only limited to sign in all pages of the document, but also to the application form, in as much as the clause mentioned in clause 7 categorically states that the registered bidder shall also be required to sign, scan and upload all pages of the bid document. The bid document is there, na? Which includes the bid document, which includes the application.
Period. Words acknowledge the following. The documents which acknowledge the statements made in the following paragraphs have to be signed.
Enough, no more. I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration in respect to their respective submissions. Let this court first take note of the rejection of the petitioner bid. In the case of the rejection of the petitioner's bid in WPC number 1384 oblique 2024 and WPC number 1385 oblique 2024. Taking into account that both the reasons, the reason for rejection of the petitioner's bid in both the cases are one and the same. Is it mentioned in the tender document anywhere about that the documents to be submitted to the application A?
No, Your Lordship, that is not, there. Only it says, Your Lordship, that the documents to be submitted, Your Lordship. Only clause 6, Your Lordship. It says the technical bids will primarily consist of the following: duly filled up application form as per annexure A. Only about filling up.
Does it say anything?
Lordship. It does not say, Your Lordship, that.
Actually, A says that has to be accompanied by.
That's not a part of it.
And Your Lordship, the other documents are there, Your Lordship. Specific reference.
From a perusal of the clause 6 of the bid document, there is no mention that the bank certificate there is no mention that the bank account details along with the proof thereof is to be provided shall comprise of the bid documents. It is only in annexure A, which is the application format of the bidder, there is a requirement of proof to be submitted as regards the details of the bank account. Full stop. From a perusal of the application form, which have been enclosed as annexure 2, Roman 2, annexure, which have been enclosed to the writ petitions, it is seen that the petitioner had duly provided the bank account details, the name of the bank, the type of the account, as well as the account number. In proof of the same, the petitioner have only submitted a certificate given by the concerned bank that he is a reputed customer of the said bank. It is also seen that major income tax return. Income tax return, where is it?
I guess. Page 64, Your Lordship. Hold on. 64, 65, 66. One three eight five euros.
Huh?
In 1385 euros, it is from page 64. And in 1384, it is page 62.
One three,
In 1384, page 62, your lordship.
where's your balance sheet? This is your balance sheet.
So then your lordship, page 65. One three eight four, page 62 onwards.
Where's the annexure to this? You didn't submit. Balance sheet.
In which,
On that ground only, they should have rejected yours.
your lordship, in 1385, your lordship will get page 69. Profit and loss account, your lordship. 64 onwards. Balance sheet, your lordship, page 70. From page 64 to page 78, your lordship.
Huh?
In WPC 1385, your lordship.
I'm
page
reading in 1384.
84, your lordship.
Hello. Okay.
One three eight five. Less the agreement submitted by the petitioner in 1384. Perhaps that it taken a round of collusion also, but that was not perhaps.
You can very well do it, taking into account that you have the same lawyers. Okay, take on level.
Which
It is also relevant to take note of that in clause 6 of the bid document, the authorities concerned have specifically mentioned which are the documents which are required to be submitted. Good stuff. It seems, taking into account the clause 6 of the documents, the responding authorities, the technical committee have decided that the petitioner in WPC number 1384/2024 and 1385/2024 was technically eligible. Well, bid was technically valid in spite of the fact there was no other document other than the certificate of the bank. At this stage, this court finds it very pertinent to take note of the amended Rule 114A of the rules of 2016. The said rule categorically mandates the procedure for grant of the Indian-made foreign liquor off license. Clause Roman 4 and Roman 5. Roman 4, Roman 5, and Roman 6. Roman 4, Roman 5, Roman 6, and Roman 7 of clause 114A bracket 1 being relevant is reproduced herein under. First, from a perusal of the above clauses, it would be seen that the technical bid of the bidders shall be opened only on a pre-notified date by the tender committee. And at the time of opening, the bidders or the authorized representatives shall be allowed to be present. This is so for the purpose of transparency. In terms with clause 5, the tender committee shall prepare a list of technically qualified bidders after such scrutiny / inquiry as it may deem necessary for the purpose. And this list would be published by the concerned district collector of the district. In the instant case, it would be seen that pursuant to the minutes of a meeting of the technical committee, which was constituted in terms with clause 3 of the bid document, wherein the district commissioner, district collector, or his delegate was also a member, it was held that the petitioner in both WPC number 1384 and 1385 of the 2024 was technically valid. And this aspect of the matter was duly informed to the petitioners, as could be seen from the records. Thereupon, all of a sudden, a decision was taken for re-scrutiny. All of a sudden, a decision was taken to re-scrutinize. At the direction of the district collector. However, if this court duly takes note of clause 6, it would be seen that the financial bids of the technical qualified bidders shall be opened also in presence of the bidders or their authorized representatives. Therefore, a person who has been technically qualified and such lists have been duly published, he has a valuable right to be considered for the financial bid. A submission, though, has been made by Mr. K.P. Pathak to the effect that a person do not have any right, the tenderer, that no right is created upon a tender unless the tender is
Even after opening of financial bids, person has a right.
it has at this stage, if this court duly takes note of the submission of Mr. K.P. Pathak, the learned counsel appearing on behalf of the excise department, that there is no vested right upon a bidder even after opening of a financial bid. And as such, he has no right to be considered. No right created on the basis of he being, the petitioners being technically qualified at the initial stage. The said proposition may be good in the opinion of this court in normal course of events. However, in the opinion of this court, however, it is also the opinion of this court that if the tender is decided, if the tender, if the settlement, if the grant of Indian made foreign liquor off license is decided on the basis of Rule 114A, which is a statutory rule, a right is a right stands conferred upon the bidder upon being technically qualified, upon the scrutiny, upon the and after having been adjudged as being technically qualified to be considered for the financial bid as per the clear mandate of clause Roman 5 and Roman 6 of Rule 114A, one of the rules of 2016. Footstep. In the further opinion, this court is also of the opinion that if a right is created for the purpose of being considered for the financial bid, for the opening of the financial bid, this right can only be taken away after duly providing an opportunity to the bidder to explain the deficiency which came into light subsequently after being initially held to be technically qualified and informed to the petitioner, to the bidder. It is this court is also the same is therefore is required for the reason that the same is required for the reason that the action on the part of the respondent authorities to be in conformity with fairness, transparency, and fairness and transparency, which are facets of Article 14 of the Constitution. In the instant case, what is seen that in spite of the fact that the petitioners in WPC number 1384 and 1385 of the 2024 were informed that they are their bids have been technically accepted, are qualified. And the bids, financial bids would be open on 16th of February, 16. On 16th of, but on 22nd of February, the respondent authorities again had taken a decision and thereby rejected the petitioner's bid. Petitioner's bid. Petitioners in both the writ petitions bids in 13184 and 1385. That too on a condition which is not there in clause 6 of the bid document. Under such circumstances, in the opinion of this court, the impugn actions on the part of the respondent authorities in rejecting the bids of the petitioners in 1384 and 1385 smacks of arbitrariness, unfairness, unreasonableness, for which the minutes of the meeting dated 22/2/2002, na? Minutes of the meeting is 22 or 24? 22/4. 2024. Insofar as the rejection of the petitioners in so and so and so and so, and WPC number so and so and so and so, in respect to TS shops, TSK 10 and TSK 6, are bad in law and required to be interfered with. Now coming back to the case, and now coming back to WPC number 1496/2024, it would be seen that admittedly the petitioners herein, the respondent herein, who is also the respondent in WPC number 1385 of 2024, did not submit the certified copy, the annual return, the income tax returns, as well as the balance sheets for the relevant periods under the certification of the, with a certification by the chartered accountant. Though the learned counsel appearing on behalf of the petitioner, a respondent, private respondent, as well as the counsel appearing on behalf of the respondents, authorities, submitted that the same has been held to be directed by the respondent authorities. But the perusal of clause 6 and the treatment so given to this clause for providing of the income tax returns as well as the balance sheets to be certified by the chartered accountant, and the emphasis thereof in the case of proprietorship firm, or in the case of partnership firm, or in the case of company, and read along with clause 2 of the tender conditions, which touches on the very eligibility of the bidder to participate. In the opinion of this court, renders the decision of the tender committee to treat the said condition to be directory unreasonable and unfair. More so when the same tender committee have been so technical in the respect to the petitioners in WPC number 1384/2024 and 1385 of 2024. At the cost of repetition, this court would like to observe that the same tender committee subsequent who initially held the petitioners in WPC number 1384/2024 and 1385/2024 had held that the petitioner was technically qualified, the petitioners were technically qualified, upon scrutiny had rejected on the basis of a document which was not a part of clause 6 of the bid document. And the same tender committee approved the private respondent's bid in spite of the fact that he did not submit a document which was mandated as per clause 6. The above clearly therefore smoke shows the arbitrariness and illegalities so committed are arbitrariness and unreasonableness. Arbitrariness and unreasonableness on the part of the tender committee, the technical committee, in dealing with the the bid committee, in dealing with the bids pertaining to TSK 6 and shops TSK 6 and TSK 10, for which the said recommendations were made in recommendations were made. Where is that recommendation? There's a recommendation somewhere I saw it, no? Recommendations were made in favor of the private respondents in WPC number 1384/2025, 24 and 1385/2024 are set aside and quashed. And the letters of acceptance which have been issued also dated so and so and so and so in favor of the private respondents are also set aside and quashed. As a result of the setting aside and quashing of the letters of acceptance of the entire bid process insofar as TSK 6 and TSK 10 is concerned, the respondent authorities, more particularly the authorities, are directed to proceed with fresh settlement procedures, thereby following the mandate of law. And further, the petition, the respondents shall also, the respondents who have paid any amount pursuant to the letter of acceptance would be at liberty to request the respondent authorities for refund of the same, which the respondent authorities shall do in as per the extent. But that question did not get answered. F-Con's thing. This was the only case left. Oh, that one, that will some other day.
Very, this 149. That division, what has happened is that the tender committee had this correctly held requirement of submission of certificate by CA mandate. They challenge that.
There are two grounds of rejection, my lord. In the envelope, I did not mention as hard copy. And second ground is that I have submitted all the document, balance sheet, network certificate to be certified by the charter account. I have submitted. Only I have submitted computer generated copies of income tax certificate return, my lord. As a result, my lord, what happened, government has lost huge amount of money. My terminal value was 51 lakhs and that has been settled on the rupees 14 lakhs.
That is why I'm not taking up your matter today.
And my lord, the departments are.
You gotta stay or not?
There was stay, my lord. They approached the honorable division bench and that was stayed.
That was stayed.
That was subsequently disposed of in the term that till disposal of this petition, the license shall be operating. And before granting.
We'll
of
have
license-
it some other day.
Yes.
List this matter on some other day. After vacation, give a date. এটা থাকি গ'ল হে 1516 না 15
My 151.
he may so may that judgment. My lord is bound by this. But the judgment, there will be some correction of that issue. Yes, Mr. Roy Chaudhary, your matter. Yes, government, what have you done?
My instruction goes, they will come on 28. My instruction goes that they will come on 28 for commission.
Who? They will come.
They will.
They've allowed it, no?
So date is fixed on 28.
It has been submitted by Mr. N. Goswami, the learned counsel appearing on behalf of the district administration of Karimganj, as well as the sub-registry Karimganj, that the application for issuance of a commission have been permitted, and the commission is likely, and the commissioner so appointed would be going to the petitioner's residence on 28th of September 2024. Taking into account the above, as the petitioner's grievances have been redressed, nothing further remains in the instant petition for which the same stands closed.
Alright.
Yes, there is another one, Mr. N. Goswami. That one, I have fixed it today. Issue notice returnable tomorrow, today, 2 o'clock. Yes, Mr. S. Burua. How does the additional deputy commissioner, district magistrate have any business out there? Yes, on the other side, Mr. Srinivasan, you are there. You are there in this matter. Yes, how? What business you have? You are nobody. If there is any problem, you have to provide the law and order, you provide. Police is there to provide. But who is to take the decision? The registrar. You are nobody to stop an election process. It means unheard of. Today in the morning, your advocate general was stating about that an election process cannot be stayed even by the High Court or the Supreme Court. And now you are saying this? The district magistrate does an election process has been made to a nullity. Set aside this immediately. Any further instructions you have? Nothing? I hope. You want the setting aside of 38?
My lord, yes. And my lord, direction, my lord, to held AGM, my lord, within 2 or 3 months, my lord. My lord,
Direction to whom?
To register, my lord.
Why register with, it is a one-man committee going.
Register, my lord, register the authority.
No, is it a one-man committee going on?
No, my lord.
Who is running the affair?
My lord, I have no instruction that respect. On 21st, my lord, the term already expired.
21st of September.
Yes, sir.
Okay, Mr. Raswa. The 21st of September, the term expired. So now I think the one-man committee must have been appointed. Has he been appointed? We just get your information. We'll have it. We have it on day after. You just get that instruction because then the direction will change. I'm setting aside this, but I have to pass a direction to the registrar for if it's a one-man committee to do it within 3 months. Because the moment 21/9 it is over, there must be a one-man committee appointed. So 41/6 will kick in. With the 41/6, it is 3 months. Okay. List the matter for further hearing on 26/9/2024 at 2 p.m. You just get that. On which date, Mr. B.K. Rajpur, the learned counsel appearing on behalf of the corporation department shall obtain instruction as to whether the registrar of cooperative society have appointed any one-man committee taking into account that the period of the what is the period of the
Period of the, my lord, cooperative society. Barangabadi Peak,
not the cooperative period of the
Barangabadi Cooperative Society Limited.
the term of the board, it was over on 21/9/2024. Agreed.
Item 28.
No, this one.
Yeah, I filed one additional affidavit for correction.
What instruction?
Fines and general, I have instructed Mr. P. N. to submit a payment. Out of town. The parent act, under which the notification is issued by this is under review. After minor mineral rules, 13, under which these have been issued, is under review.
No, I'm not on the review. I'm concerned with what is your power? What power you have for these private things? These are all private. Private, you have no business of. It is only, this is as per the 54(3), na? Whether AG appears or not, he was supposed to appear today. He has not appeared. I'm telling you. Ask him to just wait there for another few hours. Dismiss it, you immediately file a SLPA. Go there. No, I'm not doing no adjournment. This type of matters should not remain. Unnecessary matters. Here you see 5(2). No. The contractor engaged for works, projects of the government departments shall be granted mining demand for the required quantity as specified in demand. Now there is an amendment 3. The minor minerals where shall be used or consumed by government departments, the rates of royalties shall be paid as per the rates in the iman. The minor when used and consumed by the government agencies, then you have to pay. When used by central government, they are to pay. Urban Burley shall collect royalty as prescribed in the 3rd schedule in 4 installments. The first installment, this is under 3. But this is only in respect to these 1, 2, and 3. Chalo. Raho. You dispose it of. Heard Mr. I. Chaudhary, the learned counsel appearing on behalf of the petitioner. Yes, GMC. Tell me, is it possible? Understood. You are doing it in view of 352 Roman 3. You are doing it under 52 Roman 3 in view of that letter written by Mines and Minerals. Okay. Now have a look at it. Understanding or not, you kindly see 3. This is how they do it. There's no amendment. You see, the minor minerals when shall be used or consumed by the government departments. The rates of royalties shall be paid as per the rates prescribed in the third schedule, appended to the rules, and these ancillary charges as notified by the government shall be deducted. The minor minerals when used and consumed by the government agencies, the rates of royalties shall be deducted and so and so, so and so. When used shall be used or consumed by the central government agencies or agencies so and so. Where is that for the purpose of private body? You are private. Chalo. No business of this. Urban body is the person who is going to do it. See, number 4. Urban local bodies shall collect the royalty as described in the third in 4. The first installment shall be collected in so and so, the royalty. That is why. No. No. Other matters, don't worry. Today this matter finishes. Yesterday only I was supposed to finish. Fools. Okay, they have not filed any affidavit till date in all the matters. Heard Mr. I. Chaudhary, the learned counsel appearing on behalf of the petitioner. And Mr. D. Gogoi appears on behalf of the respondent numbers 1, 2, Housing and Urban Affairs, 3, the 1 and 2, and the 4 also Mines and Minerals. Okay, 1, 2, 4, 1 and 2, and Mr. D. Gogoi. D. Gogoi appears for 1 and 2. Mr. P. Naik appears for respondent number 3, 6 and 7, and Ms. S. Gogoi appears for respondent number 4 and 5. The petitioner herein have assailed the communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam Mines and Minerals Department, whereby a direction was issued to the Commissioner and Secretary to the Government of Assam Housing and Urban Affairs Department that there is no changes been effected to the notification dated 7/10/2021 for the time being, and the notification shall be applicable in relation to forest royalties in both government departments of the urban local bodies for both government and private agencies until further orders. Full stop. In pursuance thereto, now prior to that, there is another document. Huh? Yes, let us take Mr. Putomanyo's case.
We have filed the corrective.
Have challenged, petitioners have challenged the communication dated 28/7/2022 issued by the Commissioner and Secretary to the Government of Assam, Department of Housing and Urban Affairs, whereby which is the first one?
First one, my lord, 28 July 2022. That is annexure 4.
This is Annexure 7.
Annexure 7 means, my lord, in the new, I filed additional affidavit. Yes, they are, it is not.
That is the first document.
Yes, my lord.
You are challenging this document.
No, I actually need annexure 5 because as per annexure 5, my lord, these urban bodies were directed to collect royalties, my lord. And acting on this notification order, my lord, they have demanded forest royalty from us, my lord.
What is the Annexure 4?
Annexure 4, my lord, the order, my lord, by which, my lord, the municipal corporations were directed, my lord, to collect forest royalties, my lord. As per the notification dated 7 October, my lord, 2021.
So this was the first, and then there was a review made.
First is, my lord, annexure 3, that is the notification, 7 October 2021. As per this notification, my lord, as your lordship has already pointed out that minor minerals, my lord, for that forest royalties to consume, my
This
lord.
is, here there is no private,
No. In the notification dated 7 October 2021, there is no private, my lord.
no private.
No private.
Then
Then, well, here also, if you see the notification, my lord, then the rates as appended in third schedule and process as prescribed shall be applicable for fresh tenders only. So it was made for tenders. So, my lord, thereafter, my lord, this notification came, my lord, office order by 28 July 2022, my lord. That how the installment are to be collected, my lord.
this was issued by Commissioner Secretary, Department of Housing and
Urban affairs,
to be collected.
it's collected.
Because of who has said, who has also reviewed the Honorable Chief Minister on Iman in the review video with the environment and on enhancing the collection of revenue soon so and so. They'll also submit a monthly report on the implementation and take necessary to strict the approval as so and so. The first installment shall be collected at the time of building transfer and number two, next two installment during construction and the final on the completion of the construction works. So this is the office order.
This is the office order.
Thereupon comes
Then what comes, my lord, the 2-3, my lord. There's an extra 5, my lord.
2nd of March 2023,
Yes, my lord.
whereby they clarify that it is applicable to for private
Private agencies, government and private agencies.
agencies. Okay.
Private agencies.
The petitioners herein have a sale. The communication dated 2/3. Two 2023, issued by the respondent number 5. Whereby the notification dated 7/10/2021 was by which the Assam Minor Minerals Concession Rules 2013 was amended, was extended even to private agencies. Or Mr. I. Chaudhary and Mr. D. Upaman. The case of the petitioners herein, that the petitioners herein, the petitioners propose to construct buildings for their own use, on their own, for their own use, and for that purpose have sought for permission from both the GMC and the GMDA. And these authorities have been imposing have been, these authorities have made it a condition precedent for deposit of forest royalty for the grant of the necessary permission. It is the case of the petitioner that the state agency, the state that both the GMC as well as the GMDA are acting on the basis of the communication dated 2/3/2023. First, whereby the Joint Secretary to the Government of Assam, Mines and Minerals Department, have extended the ambit of the notification dated 7/10/2023, 7/10/2021, even to private agencies. First, it is seen that this court had issued notice. However, none of the respondents have filed any affidavit. First, I've heard the learned counsels appearing on behalf of the petitioner as well as the respondents. First, it is seen from the report, from the materials on report, that the Assam Minor Minerals Concession Rules 2013 was amended by the notification dated 7/10/2021, whereby Sub-Rule 3 was substituted. Full stop. The substituted Sub-Rule 3 we are only concerned with 5, no? Not with 8. 8 has no relevance. Whereby Sub-Rule 3 of Rule 5, Sub-Rule 6 of Rule 8, and Sub-Rule 4 of Rule 27 were substituted. Pushed. From a perusal of these substituted rules, sub-rules, it would transpire that when minor minerals used by the government departments or by government agencies or by central government departments the rates of royalties shall be deducted by the said departments as per the rate prescribed in the third schedule appended to the rules of 2013, and other ancillary charges as shall be notified by the government It further stipulates that the urban bodies shall collect royalty as prescribed in the third schedule in 4 equal installments. The first installment shall be collected at the time of granting of the building permission. The next 2 installment during the construction and final next 2 installment during construction, and the final installment on completion of the construction works. It is also relevant to take note of. That a perusal of Rule 3, Rule 8, as well as Rule 27 only refers to when the minor minerals is used or consumed by the government departments or government agencies or the central government. Is concerned. It doesn't show either from Rule 5, 8, or 27 of the rules of 2013 that the same would be applicable in respect to private construction to be carried out. Not involving government departments, government agencies, or central government. Furthermore, the power which is being given to the urban and local bodies to collect the royalty does not also mention that such power is to be exercised in respect to private constructions having no relation with government departments, government agencies, or central government. In fact, a perusal of the communication issued by the office order dated 28/7/2022 issued by the Commissioner and Secretary to the Government of Assam Department of Housing and Urban do not also envisage as regards collection of any amount, the collection of any royalty by the GMC in respect to private constructions. It only stipulates the manner in which the said royalty is to be collected, which is in consonance with Rule 5.3. 5.3 Roman 3. Rule 5.3 Roman 3. Roman 3. Rule 8.3 Roman 4. And Rule 27 4 Roman 4. However, the communication which have been impugned in the instant proceedings issued by the Joint Secretary to the Government of Assam Mines and Minerals Development extends the purview of the application of Rule 5, 8, and 27 even to private agencies. First, in the opinion of this court, the same is contrary to Rule 5, 8, as well as 27, as was amended by the amending rule by the Assam Minor Minerals Amendment Rules 2021, which was brought into force in the notification dated 7/10/2021. Accordingly, this court therefore disposes of the instant petition, thereby setting aside and quashing the communication dated 2nd of March 2023. This court further directs. You've got the NOC?
It is under.
Okay. Further directs the respondent authorities not to withhold the NOC oblique the building permission to the petitioners on the basis of the communication dated 2/3/2023, provided the construction which the petitioner proposes to make has no relation to government departments, government agencies, or the central government. With the above, the petition stands disposed. Right. Same. Ekeling. Yes, Mr. B. Gogoi. Where is he? Yes, others may go, others may go.
They have replied certain rate matters. So we need to, LDM from the submission authority. 10 days time will be given for filing our certificate.
What have you?
After we go
Item number
27 contract matter.
27.
Subject.
Okay, list this matter again on 22/10/2024, on which state Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI shall apprise the scope as regards the further developments from the HCI. Mr. Doctor, have you recently seen the judgment in Zal? That is a recent judgment of Justice Patiwala. That is a case where the amount has to be taken out from JAL, which was not being paid. Now, the Supreme Court say the amount has to be paid by the state to them, and thereupon realize them with interest as what do you call that heavy land revenues? Baki jai. Take your decision. Better purchase.
All right, your lordship.
Yes, Mr. Gugoi, what is this?
Those are the auction matters, those two gardens. These all right of the bank.
Auction of fruit is by the EPF authority.
That I know. So,
The last week, the Rochester director, the respondent, is the liability.
ah,
But today, what we are on, regarding, there are some liability regarding the bonus from might have paid wages in the labor. Now, we paid more than other people.
This matter come up, Millard, for it, and we heard Millard and decided everything.
no, now we don't have the time.
All liability.
No, not today.
They too, not possible.
Yeah, there's the light.
What do you want now?
No, there is a subsequent development also,
What development?
that the second tea garden has also been sold. The second tea garden has also been sold,
Sold.
2.75 crores. That is as per the affidavit filed by PF.
Who has sold?
The PF authority has sold the second tea garden. They filed
How
an
much?
affidavit today.
Tea garden is 2.75. Huh? Only.
Reserve price was 2.10.
First round, well, okay, fine.
Nothing wrong with the tea gardens in a sense. People get more money out here with 2 kathas of land. What's wrong? Tea gardens, how much? How big?
Area is there, it's describing. It's on record, the area except everything is on record. The lease deeds are there, everything is there. The entire tea state with.
Now, what do you want?
Keep opting on the bonus amount can be made from the auction. The now like time.
He have sold it to somebody who will take care of the bonus. Why you are taking care? Last year's bonus, you want to pay. Last year bonus, we'll look into it. But this year, I'm only concerned. Last year, you have not paid, that is your lookout. But the question is this year. This year, new one will pay.
I mean,
There's no urgency. If this, why you are saying about I would have, normally this bonus question only comes just before the election, judge. So they will pay the bonus of 20% or 16%.
same for- continue, but money will not be.
Very good. Why do you want the bonus now?
That liability was on the major matter, two major liability. Fail. It will have to be matter paid from the. Yeah, there is the possibility.
Huh? No. No, madam, kindly understand the bonus is paid on the date for this coming puja. It's not for the last year.
The liability card, that's a part for when you take it, 19,124.
How much?
For one is concerned, 1 crore 8 lakh or better. And the other part is 30 lakh.
And how much is the amount they have?
8 crore. 8 crore.
How much is your due?
No, my total dues is 6.5. Ah, that is, that, to that extent, they are right.
But one thing, tell me. This is not an IBC.
No, it is not.
Then once a sale is being made by them. But what happens to the collateral? As regards where you have a collateral, wouldn't that sale also proceed with it?
Yes, the collateral.
Because if it's an IBC, it's a different thing. With the final resolution plan, everything goes.
Everything.
But in this case, what happens?
This case, the primary security for the, as far as the term loan is concerned, the money which was actually paid towards the leasehold premium, the upfront amount of 3.2, which was paid directly into the account of ATCL. That amount, against that amount, the leasehold rights of two tea gardens were there. Against the other loan, my lord, that is 4.0 crores of cash credit, that was on the stocks, the hypothecation of the entire stocks. Now, as we know it, my lord, we do not know that any stock exists as of today.
But that the stock was made by somebody else.
Yes, that and also in future, because this lease was for a 30-year lease. Now, ATCL, what the situation today is, 3.20 crores was the lease upfront money for the entire period of 30 years. Now, in less than 1 year, the lease is finished. My security is gone as far as the tea garden is, both the tea gardens are concerned. My question is that, on one hand, they are keeping the 3.2 crores minus 1 crore lease amount, that also they are having. Into this chart that they have annexed, they have put in everything possible. They've put in manager's salary, this, that, only the MD salary is left, I think, to be adjusted.
Which salary?
The managing directors, only that they have left out. Rather, everything they have put in. But they've even included the last year's lease rental. How can they put everything when their own going concern is being sold?
And see the payment of bonus act. I don't think.
Payment of bonus act, 8.33%. Yes, that they will get. Beyond that, 20%, how can they? Because that
You're giving
depends on
20? You can't give 20.
Can't give 20.
You can choose among 8.3 to 20. This is the area. But when it's a loss making, we have sold it. Who are you?
8.3. And there will be a difference, my lord, of 71 lakhs.
Okay, we'll have it some other day. When? 26, 27.
26 is Thursday, I think. Thursday.
Thursday 2.
That-
That will be listed on.
Or top of the list, perhaps, your lordship.
Huh?
Top of the list, perhaps, your lordship, will consider this
Top
matter.
of the list, how
Some-
many matters are
this-
there? Let's
This
see.
matter will require some time.
Today's top up of the list, they have been finished or not, Mr. Sinha? All finished.
Finished, my lord. So we may also finish on that.
Uh,
Yeah. On that, the top of the list will be grateful, my lord. Consider.
no, but I'm not going to do the hearing, huh? No hearing. Because you see,
Let it be only on the bonus part at least.
yes, only on the bonus point, 26, na?
Lordship.
Already 33 matters are there. Huh? 33 matters are already there. Yeah, 26. Not possible. You have got all your matters also in the text matters also. on those. These are all top of the list.
This
There
matter
you are
is-
losing.
This matter is
That is
coming
why
in
you don't
orders
want.
matter, my lord.
No, not losing means Krishna will be allowed then.
Otherwise, this matter is coming up as an order matter. This should be really an admission matter.
Huh?
Matter in the admission column. This is now coming in the orders column. These are
Orders
other
column
kinds-
or admission column, when it is top of the list, it's okay. Now we'll do one thing, we'll have it on 27, top of the list. Okay, it's the matter on 27. We'll have it in the morning hours first. Very good. Oh, that matter, what happened? Who is appearing for this matter? That Brahmo matter, there's somebody in that BTC matter? Ajay, BTC matter is something. There's one matter, another pattern matter. This J Brahman. Eight, 11 to 4. To Kali 4 of it. 2000.
No,